Okay, good morning, everyone. Welcome to Convocation and welcome to those joining us via the public webcast today. We are now regularly webcasting as part of our commitment to outreach and transparency in our governance. I'd like to review instructions for the phone system for those participating by phone. Once we go through the roll call of who's on the telephone, I'll let everyone know that we'll be placing those calling into the meeting into what we call lecture mode, ably assisted by Mr. Lerner. You're still continuing in that today?
I am, thank you.
Thank you so much. This means that from our end, we're muting all callers. Once muted, they'll be able to hear the meeting but can't speak. So it is *6 from our end for everyone. We will, of course, need to come out of lecture mode to hear callers who wish to speak and vote, and we'll do that following the presentations of reports and motions. And at that time, unless callers wish to speak, they are to *6 their telephones as we have done in the past. So let me go through the list who I believe is on the phone. Mr. Bannock.
Present, thank you, Chair.
Mr. Beach.
Yes, present, thank you.
Ms. Boyd. Ms. Clement.
Present, thank you.
Mr. Finkelstein.
Present.
Thank you. Ms. Haig.
Present.
Mr. Krishna. Mr. Laurie. Ms. McLean.
Present.
Ms. Politza. Ms. Richardson.
Present.
Ms. Strasburg.
Present.
Mr. Strasburg.
Present.
Mr. Sway.
Present.
Okay, thank you. Is there anyone else on the phone whose name I did not call?
Robert Bird.
Thank you. Mr. Bird. Anyone else?
Lori Calista.
Okay, Lori, thank you. Ms. Politza. Okay, and I'll just call the names of those who did not respond earlier. Ms. Boyd. Mr. Krishna. Okay, thank you.
The conference is in lecture mode.
I'd like to welcome David Wright, Chair of the Law Society Tribunal, who's attending for the Tribunal 3-year review report. I'm pleased, I would just like to review some of my engagements since the last convocation. I was very pleased to be invited to attend the opening of the legal year in Hong Kong in early January. While I was there, I met with members of their law society and bar council. And as you know, it is a divided bar in Hong Kong, so there are two regulatory groups. I also visited the Department of Justice in Hong Kong. It was a great opportunity for me to learn about their judicial and legal system. There was a symposium of international guests before the opening of the legal year, and there was great interest in our Canadian approach to the rule of law, freedom of expression, and we had some good discussions at the Department of Justice about the role of the Attorney General and, again, free speech in Hong Kong. When I returned, I attended a number of meetings with our own members and legal associations. We hosted a regional meeting in Cambridge with Central, South, County, and District Law Associations. Ventures from the area were in attendance: Janice Krieger, Ross Earnshaw, and Andrew Spurgeon, and I thank them for attending. The evening started with a reception with local members. We then sat down with local association representatives and other legal association representatives for a roundtable discussion on current issues. We've had a meeting with the Treasurer's Liaison Group, again composed of the executives or representatives of the executives of a number of legal organizations. We talked about our mutual initiatives And Ross Earnshaw attended and made a presentation and led discussion on our initiative looking at compliance-based entity regulation. We also had our second meeting of the Early Careers Roundtable. This roundtable has been very well received by our profession. We are still having requests to be added from various organizations and individuals. And we had a very lively and good discussion, again, of a number of our initiatives. In particular, Jacqueline Horvat attended to lead a discussion on mentoring, and Teresa Donnelly led a discussion on compliance and entity-based regulation. On January 18th, I was also delighted to attend a dinner which we sponsored for the Ministry of the Attorney General's Elders Justice Forum. There were 14 elders from First Nations, Métis, and Inuit communities. Also present were members of the Deb Wegwin Committee on the implementation of Justice Yakabuchi's recommendations on Aboriginal justice, and also the Deputy Attorney General and Ministry of the Attorney General staff. And I gave a welcome on behalf of the Law Society and also an outline of some of our key initiatives. I had a chance to talk about our handbook on everyday legal problems, which we have just had translated into 3 Indigenous languages. And again, that was very well received. Ms. Corsetti will be speaking to you about that further this morning. On January 26th, we hosted, along with Claire, an event to commemorate the International Day of the Endangered Lawyer. That day is actually January the 24th, and it is a day to reflect on the plight of lawyers around the world who risk harassment, persecution, injury, and even death as they work to protect the rights of those who need it most. The speaker was Georgette Gagnon, who is the former Director of Human Rights for the United Nations Assistance Mission in Afghanistan, an international human rights lawyer and advocate. She gave a thoughtful, candid, and inspiring speech. She, as I say, I should add, was an employee of the regulatory department at the Law Society briefly in her past life. This event was totally subscribed, and there were a large number who are looking forward to seeing it recorded, I think, on our YouTube, and I understand I am supposed to say platform, not channel. Finally, along with a number of other benchers, we volunteered last night at the dinner service for Lawyers Feed the Hungry. Thank you to all benchers who volunteered their time, and for those who were not able to participate last night, there will be more opportunities. I'd like to remind you that tomorrow, January 29th, is the deadline for nominations for the Law Society Awards. Of course, our medal, the William J. Simpson Distinguished Paralegal Award, the Laura Legg Award, the Lincoln Alexander Award, and the new Shirley Dennison Award. And we look forward to reviewing those nominations in time to decide for the awards ceremony, which will be on May the 25th. Our first call to the bar of 2016 is scheduled for tomorrow. It's always an honor and a pleasure to preside over the call to the bar. There will be approximately 190 new lawyers after tomorrow, and we are granting an honorary doctorate of laws to the Honorable George Adams. I'd like to congratulate the Honorable Stephen Gouge, our former bencher and former judge in the Court of Appeal for Ontario, on his appointment to the Order of Ontario. Of course, recognizing his significant career and contributions to Ontario, including as a commissioner for the public inquiry into the pediatric forensic pathology issue. And this led to a fundamental restructuring of the delivery of forensic pathology services in Ontario. Finally, on the congratulations list, I'd like to congratulate our CEO, Robert Lapper. Next week, on February 2nd, he will be receiving the Distinguished Alumni Award in Law from the University of Victoria. So congratulations. I indicated at our December convocation, one of our strategic priorities is governance improvements, and a specific initiative identified by benchers was developing an education plan for board professional development. That planning has begun, and we have arranged for our first session to be for the convocation day in February. I'd like to emphasize that having a regular program of professional development relating to benchers' responsibilities and responsibilities of convocation is designed to enhance governance, leadership, and skills, knowledge of the Law Society and the environment in which it governs, and there will be more information following on that. Upcoming events on on February the 8th, between 5 and 7, there will be a free webcast to provide lawyers and paralegals with an opportunity to learn more about compliance-based entity regulation and provide questions and feedback to task force members. The program will be eligible for up to 2 substantive CPD hours, and I'd like to encourage all members to register and tune in. There is our consultation paper on the website, and we ask those interested in commenting on that to provide submissions by March 31st. For convenience and to help facilitate feedback on the consultation paper, there is, for the first time in Law Society history, an online submission form. This is the first time we've used an online form to solicit feedback from interested parties. We hope the approach is user-friendly, convenient, and enables many interested to comment on the consultation paper. Black History Month is February, and on February 9th, in partnership with the Canadian Association of Black Lawyers, we invite you to hear the celebrated author Lawrence Hill discuss his newest book, The Illegal. And that will take place from 5:30 to 7:15. It will also be available by webcast, and as usual, there is a reception to follow. Finally, our luncheon guests today are the Honourable Rosie Silberman, Abella, and the Honourable Michael J. Moldaver of the Supreme Court of Canada, as well as the Chief Justice of Ontario, the Honourable George Strathy. So let us now turn to the agenda. Our first item is the consent agenda. Is there anything on the agenda that anyone wishes to change out of the consent agenda to discussion? Seeing none, anything on the phone?
The conference is no longer in lecture mode.
Any issues in the consent agenda anyone wishes to add to our discussion agenda? If not, moved by Rajadan, seconded by Isfahan Morali, that
The
convocation
conference is in lecture mode.
approve the consent agenda at tab 1 in our materials. All in favor? Anyone opposed? Opposed on the phone? Carried. Okay. Next, I'd like to invite Ms. Horvat and Mr. Wardle to speak to the Mentoring and Advisory Services Proposal Task Force report.
Thank you, Treasurer, and good morning. In November 2013, the Law Society established the Mentoring and Advisory Services Proposal Task Force to consider the nature of current mentoring and advisory programs and to determine how to better address and enhance advisor and other support services for lawyers and paralegals. Peter Wardle and I are pleased to be here today as co-chairs to present the final report of the task force, which can be found at tab 2, page 18 of the report. And the motion is on page 22, paragraph 2. First, I'd like to thank the current and the past members of the task force, as well as the past chairs, including Treasurer Minor, Howard Goldblatt, and Linda Rothstein. Most importantly, we'd like to thank Diana Miles and Sophia Spardakos for their hard work and unwavering commitment to this initiative.
And the Greek quotes.
The recommendation in this report is ambitious, and it reflects Convocation's inclusion of this issue in its strategic priorities, particularly as one component of the Law Society's commitment to lawyer and paralegal competence. The purpose of the Law Practice Coach and Advisor Initiative described in the report is to provide guidance and assistance in the development of competent legal professionals through supports that use a flexible, accessible, and evolving approach. There is ample evidence to support the need and the desire for a more coherent and professions-wide commitment to enhancing coaching and advising for lawyers and paralegals throughout the province, and for one that engages and collaborates with services already in place and provided by organizations such as the Advocate Society, the OBA, the Criminal Lawyers Association, and I'm only naming a few, as most organizations and associations in the province have such programs available. As envisioned by the task force in its report, the Law Society's role is not to deliver the supports entirely on its own, but rather to facilitate a more systematic province and practice areas-wide approach to such supports, with the Law Society acting as administrator, coordinator, and facilitator. It will do this using a collaborative approach that engages those organizations already doing valuable work in this area, while seeking ongoing input from users, coaches, advisors, and those organizations and associations who offer mentoring and advising programs throughout the process to ensure that the implementation of this initiative evolves effectively. The structure of this initiative allows it to develop incrementally to reflect proven needs, available resources, ongoing stakeholder engagement, and an evaluation of the initiative over time. Before Mr. Wardle gets into the details of the proposal, I would like to briefly reflect on some terminology which is critical to an understanding of this initiative, of what this initiative is all about. Mentoring is the traditional term that the professions have used to describe peer assistance, particularly focused on networking and career advice. But as the professions have evolved, what legal professionals need more of, and what many organizations provide already in varying degrees, is what the task force calls coach and advisor supports. Advisor supports focus primarily on limited scope assistance directed at guidance on an immediate issue. Often, this may be related to a file-specific question, an ethical dilemma, or a practice management issue. Advisor supports are generally short-term. Coaching supports, on the other hand, typically have longer-term objectives of fostering best practices. They provide the kind of longer-term supportive relationships that reduce isolation and assist to enhance competence, confidence, and connections. But the difficulty for many lawyers and paralegals is knowing where to begin to locate a coach or advisor who can assist them. And this challenge can be even greater for a sole or small firm practitioner, or for those who practice outside a large city center, or for our new licensees who are still developing their networks and contacts. We envision this initiative becoming the go-to place for lawyers and paralegals when they are looking to connect with a coach or an advisor. whether it be one on the Law Society's roster or a coach or advisor from another organization's program. Now I'll turn it over to Mr. Wardle to describe the details of the program.
Thank you, Ms. Horvath.
So, I'm going to run through very quickly the sort of guts of the program, if I may. First of all, paralegal and lawyer licensees will be able to access both advisor and coach supports. Secondly, they'll be able to do so voluntarily. So this is an entirely supportive program aimed at enhancing competence. It's not in any way linked with the regulatory side of our organization, and no one's going to be compelled to take part in it. Third, the initiative is going to be open to all licensees, but initially as it develops, we're going to focus on already identified communities of need. For example, sole practice, small firm licensees, new licensees, racialized licensees, licensees seeking succession planning advice, licensees within defined practice areas of family, criminal, real estate, civil litigation, and wills and estates. But I want to be clear that this is not intended in any way to restrict us from being inclusive and being open to moving into new areas as needs arise. Fourth, supports will be accessible throughout the province using a variety of formats with particular attention to the use of technology to make connections. Fifth, and some people have asked me, well, doesn't this just mean it'll be centralized in the Law Society here in Toronto? Well, there will be some, obviously, administrative support that will be run from the Law Society, but the intention is that this initiative will be province-wide. Sixth, the initiative will work with the programs and supports currently offered by legal organizations and associations or developed by them in the future. If a licensee seeks advisor or coach assistance and a legal organization offers a relevant program, the administrator will seek to connect the licensee with that program. If no such program is offered, the Law Society will seek to fill that gap and connect the licensee with the support that he or she needs. So for example, if the Criminal Lawyers Organization, Criminal Lawyers Association already has a program, as we understand they have, our role at the Law Society may just be connecting someone who doesn't know about that program to that program. We're not going to compete with existing programs, but I'll say this, that the idea of a coach and advisor initiative is actually well beyond what we would consider as traditional mentoring. So for those of us who've been in organizations like the OBA and the Advocate Society, where mentoring is really considered networking and hooking up young lawyers with older seasoned practitioners, that's not what we're talking about here, folks. We're talking about something well beyond that. Next, the initiative will develop a formal roster of coaches and advisors to further build the infrastructure needed to support licensees. It will facilitate the recruitment and training of advisors and coaches experienced in a number of areas and from diverse backgrounds. It will also engage and consult with users, coaches, advisors, and organizations on an ongoing basis to enhance and evaluate the initiative over time. It's not intended that this is going to be a kind of a box that we fill at the beginning and leave it in place. It's going to develop organically from a very slow start, and we're going to kind of feel our way as we go along. Next, given the time and commitment that participants and coaches and advisors will give to the initiative, the task force has also recommended that they be eligible to claim their entire 12 required hours of CPD annually if they meet certain requirements. Currently, we do have available up to 6 hours for services like mentoring. The PD&C committee supports this component of the initiative. And lastly, evaluation of the initiative is built into the proposal with annual reports beginning in 2017, and a full evaluation in the fall of 2019 once there has been a reasonable opportunity for implementation of the initiative. So Jacqueline and I thought it might be useful to just give you a couple of examples of how the initiative is going to work. So let's say you have a client file that becomes more complicated due to unexpected factors that are new to you, and you need an experienced practitioner's help to work through various scenarios in the file matter to ensure that you're assisting the client optimally. We would put you in touch with an advisor who would work with you on a short-term basis to manage your way through those important issues on that one file. And I want to be clear again that this is to work for all licensees. It's not just lawyers, it includes paralegals. We've had paralegal representation on this committee, and the program will be rolled out at the same time for both professions. So that's the advisor part of the initiative. Give you a second example. You're a new sole practitioner or a practitioner striking out on your own for the first time, and you need assistance and advice on how to establish your firm. Best practices in setting up your practice, management of the business, and ongoing client work. And of course, the Law Society already has resources in these areas, and there are things you can access from our website. There are written materials. But this program would set you up with an experienced practitioner who could give you ongoing coaching over a period of time on what we would call a professional growth basis to work through the various issues you should be addressing as you set up your new firm. And this coaching might be one-on-one, but it might not be. There might be situations where it could be done on a team basis or on a remote basis with one coach working with a group of practitioners. And it might involve individuals with similar interests. For example, if there's a group of young lawyers who are interested in a particular practice area like Aboriginal law, we might be able to hook those people up, and it might be remotely, with somebody who could participate in a webcast, some kind of what you would call a focus group over a more sustained period of time. That's the kind of coaching element to this initiative. And again, the idea is that we would start this out very slowly, feel our way along, and develop it over time. So to try to just sum this up, I'm excited about this. I think a lot of the people involved in the initiative are excited about it because it's a very important step forward for us in dealing with something that we consider to be one of our priorities, and that is competence and learning and support of young practitioners in both professions. We're going to develop it in a careful and incremental way. Hopefully we'll be able to balance our resources and get feedback as we go. And finally, I think on a longer term it will represent a bit of a culture shift for us, and it will hopefully make coaching and advising an integral part of both professions' competence culture. So I wanted, just before I sit down, to address the budget. As everyone knows, I'm co-chair of Audit and Finance, and so matters relating to the budget are near and dear to my heart. We have budget information in the materials for a 3-year period, and it really accomplishes a number of things. First, it signals the importance of resourcing this initiative seriously and appropriately from the outset. So you'll see we've given you numbers not just for the first year but for the second and third year. Secondly, it enables the Law Society as the administrator to develop more of a long-term plan as to how to support this initiative. And third, it enables approval of the first year's budget immediately using the second and third years as a forecast. Now, the first year number is going to come out of the contingency because unfortunately we couldn't time this report to match exactly with the budget cycle. So if we could have sped it up and had it in place for last fall, we would have done so. We knew it was coming down the pipe, but unfortunately we could only get here today. But effectively, it will mean the contingency of $1 million is reduced by $250,000 in 2016 with respect to this initiative. After that point, the numbers will increase as we go from 2017 and into 2018, will be added to the budget cycle and will be approved as part of the budget in the normal budgeting planning cycle. I should indicate that we're not saying that this is all the money we may need for this initiative. We may need more. We may be back to you in the future with a request for more money. But this, at this point in time, is what we think is realistic to develop the project and start laying it out. So just to close, I think all of us who worked on this initiative think it's a very important step forward. I think we've worked very closely with the working group on racialized licensees. We've had a lot of feedback from the work that's been done by that working group. And to a certain extent, and of course that working group is a little behind us in reporting to Convocation, but to a certain extent, I think what you're going to find is that the two reports will dovetail very nicely on this issue. It's an important initiative for us, and I hope it will be supported by Convocation. The motion, which is in board books, is being made by me and seconded by Ms. Horvath.
Thank you, Mr. Wardle. Okay. Okay, I'm developing a list. Okay, I think the first person is Mr. Brett, followed by Mr. Faulkner.
Careful. Thank you, Treasurer, and I note that Convocation as a whole breathed a sigh of relief that I managed to make it here without tripping. So I rise to strongly support this initiative. Competence is at the heart of our regulatory mandate, and it's clearly in the interest both of the public and the profession as a whole that the Law Society offer greater support for mentoring. With the growth and the complexity of the profession, many lawyers do need assistance to develop practice skills and competence. And the approach that's been developed by the committee, of which I was part, I think is a very sensible way to roll this process out throughout the province. And as co-chair of Audit and Finance, I have always strongly supported prudent spending of our members' fees. And to my mind, this is exactly the type of new program that deserves the prudent support and expenditure of our resources. In closing, I note, as my co-chair did, we're funding this out of our contingency fund, but it will become part of our ongoing budget. And I think that it's incumbent on Convocation as a whole, as programs like this, which are at the core of what we do, and we move forward with them, we also keep in mind that in order to keep our spending in hand, in future years we're going to have to look for savings amongst some of our programs that are somewhat further than the core than this. So, as I say, I think this is an important program and deserves the support of Convocation. Thank you, Treasurer.
Thank you, Mr. Brett. Next, Mr. Faulkner. Followed by Ms. Ross.
Treasurer, through you to the chairs of the task force. First, I want to commend the work of Mr. Wardle and Ms. Horvath and staff. I'm not reluctant to express criticism when I feel it's warranted, and I'm not going to be reluctant to express support when I feel it's warranted. I cannot emphasize enough how right Mr. Wardle is when he talks about a culture shift. This entire notion that mentoring can be accomplished in a social setting through a simple volunteer system, I am grateful to say has now been recognized to have passed with a bygone era, with smaller numbers of professionals, far more circumscribed set of problems. That was something that worked once upon a time. It doesn't work at all anymore. And so people have been left behind. What this proposal envisages is the development, what this report envisages is the development of an incremental process. We're just at the beginning of it. I'm extremely delighted to see the notions of cultural competence being part of the qualifications of those who will be on a panel of advisors. I was obviously a proponent of the issue of mentoring right back to February 2011 when I distributed a lengthy memo about it. The sign of collegiality, support, and actually many resources at Convocation is best exemplified in this exercise. Because while I may have been there at the start, to be honest, I've had to pass the torch because I have not had what I would have thought the right time to get this job done. And my colleagues took the torch up and have done a superb job. And I simply want to say that from the point of view of someone who sits on racialized, and so I get an opportunity on the racialized working group, I get an opportunity to see and hear the challenges people are facing in the communities. Through my work, I get a chance to see it. The idea that we are having this culture change and that we are prepared to take this issue on and be a leader on it is gratifying. I think this is a very important day. It's just the beginning, but I think people should take great comfort that the Law Society is making this change. And I, for one, commend the task force. I sit on it, but I didn't do the work, respectfully. I really want to emphasize that this is a beginning and that what we should be doing now is recognizing that the leadership piece to this is developing that roster of advisors that people will feel safe accessing. So I congratulate my colleagues and thank you, Treasurer.
Okay, thank you, Mr. Faulkner. Ms. Ross, followed by Ms. McGrath.
Thank you, Treasurer. I too echo the comments of Mr. Faulkner and express my gratitude and thanks to all who served on this task force. This is an extraordinary achievement in my view, and I'm speaking with the long tooth of a life benchers, having served here since 1995, and seeing this organization evolve in its programs and initiatives. And this is one of the most exciting and to me meaningful initiatives I've ever seen come through this room. And to you, Treasurer, I want to particularly say that this is an important and wonderful part of the legacy you will be leaving the profession. And I personally wish to thank you for that initiative. I had a question at paragraph 39, the qualifications for people who are going to put themselves forward to act as advisors and coaches are set out. And I looked at the list, which is in A through F, and I understand it's not exhaustive. However, when describing the essential competencies at paragraph D, it struck me that reference to professionalism and ethics is missing, and I don't think that was an intentional omission. So I wonder if the task force might consider that addition should be a friendly amendment.
So I think it's an excellent suggestion. The report, the actual motion. Just gonna go back to, I don't have a word. I mean, the components of the initiative are set out in paragraph 14. It wasn't intended that every single paragraph of this be adopted as part of a motion. So I think what we'll do is we'll take that suggestion back and it can be looked at by Diana Miles and her staff, but it makes perfect sense to me.
Is that satisfactory, Ms. Ross?
Thank you, Treasurer.
Thank you. Okay, Ms. McGrath,
Thank you,
followed by
Treasurer.
Mr. Gottlieb. Excuse me.
I stand to express my wholehearted support and enthusiasm for this program. I think this is long overdue. It certainly looks like it's going to fill a gaping need in the profession. I do note that I happen to, excuse me, I happen to fall into 3 of the 5 categories, I would think. I'm a sole practitioner in what some might regard as a remote location, 800 kilometers north of here. I practice in 4 of the 5 identified areas of practice. And some might think I should be thinking about succession planning. I was fortunate early in my career to be asked to be a member of council in the OBA. And because of that, I developed a group, a support group, and mentors that I could contact when I had a problem. Not everyone is as fortunate as I was and has had the benefit of that kind of assistance. So I think this is long overdue. I think it's very much what the Law Society should be doing. It actually harkens back to what practice, the advisor role, harkens back to what practice advisory used to be when I first started to practice, where you could actually call practice advisory, talk to a lawyer, and obtain legal advice and on whatever problem you had. So I think it's a very good program, one we have to support and wholeheartedly support, and I think we have to make sure that it receives the appropriate funding to be successful.
Thank you, Ms. McGrath. Mr. Gottlieb is next on my list, followed by Mr. Callahan. I think we are having, and I have you on, Mr. Lerner, also. Just reminding everyone that we do have a fairly full agenda, and I think new points will be most gratefully received. Compliments, I think, are hard to turn down, though. So, if that's what it is, could you just keep it a bit brief? Thank you.
Thank you, Treasurer. I'm still going to start off with a compliment to Ms. Horvath and Mr. Wardle. I think a lot of time and effort have gone into this report, and they and their committee have done a splendid job. I'm not going to go through all the comments I prepared for this morning, but I would like to say a few things. First of all, when I became a bencher back in 1995, we had a program in place, a practice advisory program, and it was run by Susan McGrath, who went on to look after quality control at Legal Aid Ontario. And the way that program worked, it was if there were lawyers that had a good number of complaints against them, and sometimes lawyers who were referred by discipline, an appointment was made for them to come in and speak to 2 benchers who would make suggestions and advice to help them in their practices. That program was ultimately disbanded. I don't know why it was disbanded, but I would have liked to see some mention of that in their report, particularly a discussion of the success of that program and why it was ultimately done away with, because it might have been instructive at present for what is being proposed. I also realize that what's being proposed is in accordance with Convocation strategic plans. And I'm pleased to see that this initiative is going to be a voluntary one. Unfortunately, we've had experience in the past where programs that start off to be voluntary turn into mandatory, and they apply to lawyers who don't need them. And I trust that that will not happen in this case, because it would take a lot of meaning out of this program and this initiative. I think I'd like to also point out that there are a huge number of excellent resources that are available at present to the practitioners who this report and initiative is really aimed at. As the report notes, it's focused on sole practitioners, small law firms, and other groups that would benefit from it. And we already have a huge number of resources. Our continuing professional development program offers a multiplicity of programs. Diana Miles and her staff have done a fantastic job. We have good presenters, we have good materials, we have practical materials, and those programs are accessible, whether live webcast or in person. So we do an excellent job of continuing professional development. We have a Soul and Small Firm Conference that is going to be coming up in June. And I would like to read you from that blurb advertising the program. It's about new ways to improve your practice's efficiency and to remain relevant to your clients' needs. Our presenters deliver practical advice designed specifically for the solo and small firm practitioner, whether you're just starting out well into your career or somewhere in between. There's an exhibitors forum which showcases quality products and product services. There's a reception that's going to provide an opportunity for the attendees to network. So we do a tremendous job. There already has been a cultural shift, and this initiative is going to hopefully continue that. I also want to point out that we have a practice management outline, a practice management helpline, and if you go to the internet, it'll take you about 30 seconds, if that, to find it. And this is what it says there. The Practice Management Helpline is available to give you valuable insight into law society regulations, as well as your most pressing ethical and practice management issues. So we have a great number of resources. There's other resources I could also mention. I'm not going to go into it. We already have a huge number of resources aimed at the same practitioners that this new initiative is focused on. Of course, I'm concerned about the cost. I think the cost, quite frankly, is worthwhile, and I'd like to wish every success to Ms. Horvath and Mr. Wardell and their committee, and express my wish to Convocation that this initiative works out in the way that they intended to work out. I think it'll be a tremendous benefit to the profession.
Thank you,
And
Mr.
the public.
Thank you, Mr. Gottlieb. Okay. Next is Mr. Callahan, followed by Mr. Lerner.
Thank you, Treasurer. This is indeed an ambitious project, but one that can not only be of great benefit to the profession, but ultimately the public. So I support this project. I commend those who have, on the committee, have worked hard towards it, those who sat, frankly, in the wilderness for many years while they proposed it, including my friend, Mr. Faulkner. And so this is a terrific day. My comments relate to something that I think requires careful consideration if this ambitious project is to succeed. In 2 words, privilege and confidentiality. Privilege and confidentiality are obviously the essence of our profession. They belong to the client. When mentoring, the issue of privilege and confidentiality must be given careful consideration, particularly where the inquiry is to provide legal guidance, or as Mr. Worrell explained, I believe it's advisory services. This is not only important for the client, but to ensure that the mentor and mentee don't interfere with any of the client's privilege or right to confidentiality. In saying that, I say this program ought not to, and with careful thought, need not succeed at the expense of the client's right to privilege or confidentiality. And I know the committee is looking at this issue, but frankly, I believe all of us at Convocation have an obligation to turn our minds to this issue. And so I look to the committee for their final recommendations on this issue, and I hope all of you will consider that so that this important project succeeds within the confines of the rule of law, including the right to privilege. Thank you.
Thank you, Mr. Callahan. Mr. Lerner.
I wonder if I might, just before Mr. Lerner gets up, just respond briefly to that. The committee did spend some time considering issues relating to confidentiality and solicitor-client privilege. There are already a number of protocols in use by the Law Society and Law Pro to deal with those kinds of issues. I think our decision was to leave that to the implementation stage of this initiative, where a protocol will be developed, and it will come back as part of the ongoing evaluation of this initiative to PD&C for regular review, so that will be one of the issues that will come back. But essentially, we expect that there will be some protocols put in place to protect confidentiality and solicitor-client privilege, and it may, in fact, start with when a person hooks into the program, they are probably going to have to sign some kind of simple application form, and there will be something in that form that will require them to respect solicitor-client privilege and confidentiality. We don't want our mentors to be in a position where they have to run conflict searches, and so we will give attention to that issue as the initiative is developed.
Thank you, Mr. Wardle. I have next Mr. Galati, followed by Ms. Lipa, followed by Ms. Go. I'm wondering if we can cut it off there unless someone has something new to say. Thank you.
I'm not going to repeat the comments that had been made before me. This type of program has been implemented in Middlesex County by the County and District Law Association. The program has been up and running for 2 years. It is a successful program, and so what I'm going to do is issue a challenge to all those thousands who are tuning in on the webcast this morning to encourage each and every one of their own law associations in each county and district to adopt this as a core responsibility. The program will depend upon the support of all members, young and old, those who are just entering the profession, and I can't think of no better place for it to start than on the ground at home. So the challenge is to each and every one of the county and district law associations to adopt this as a core principle and implement it as quickly as possible.
Thank you very much. Okay, Mr. Galati.
Thank you, Treasurer. I just have a question. Mr. Wardell made it clear that it's completely voluntary. I wonder if the committee put its mind to, or should put its mind to, not making it obligatory, but at least having a mechanism for the most vulnerable group, as I perceive them, that come across my phone in my office, and that is the lawyer that chooses or is forced to into sole practice from the day they get called to the bar. And that's where, in my experience, the problems start. If there shouldn't be a mechanism that the Law Society be satisfied that they either have a mentor in place, and if they don't, hook one up with the Law Society. It seems to me that vulnerable group, we should make an exception to the completely voluntary nature of the program. And at least satisfying ourselves they're hooked up, because they're on their own from day one.
Well, I guess my only response is that I'm not sure that that was squarely within the mandate of our committee. It is something that could be considered by PD&C as part of its review of licensing requirements, but it is, at the moment, it was certainly outside the purview of the work we were doing.
Thank you. Ms. Lipa and then Ms. Go.
Thank you, Treasurer. I'll be brief. I'm sure Ms. Horvath saw me smiling from ear to ear as I heard the announcement. On behalf of myself as a paralegal and on behalf of our profession, I would like to commend this task force on this initiative. It is something that has been greatly needed in the paralegal profession. The notion of colleague support and collegiality within both professions in order to support competency and excellence is truly a powerful thing. I am proud to be a part of this organization for this reason, for many others. Bravo to all of you, and you have my full support.
Thank you very much, Ms. Lipa. Ms. Go.
I fully support the initiative. I just have one question, because I know that we're going to conduct an evaluation at some point in the future. And just an idea or suggestion for the committee to consider, to start looking at what kind of data that we're going to collect in order to evaluate the success. So for instance, we may want to collect data about who are the coaches and advisors, who access this kind of program in terms of breakdown of the areas of law, sole practitioners, racialized groups in a disaggregated manner, whether there is gender difference, in order to know that whether the program is actually truly available and being taken advantage of across the profession. So that's just suggestion I have.
So I think that's a very valuable suggestion, and we will pass it on to Ms. Miles.
Okay. Thank you. I'm now going to call the motion. All in favor? Any opposed on the phone?
The conference is no longer in lecture mode.
Motion carried. Okay, next, report from the Professional Regulation Committee, Mr. Mercer.
There are two items at tab 4 in the report from the Professional Regulation Committee. One is for information. I don't propose to speak to that unless there are any questions. The item for decision is at tab 4.1, and it is a motion for an amendment to the rules of professional conduct dealing with retired judges returning to practice. The motion is moved by me and seconded by Mr. Chavis. Perhaps the way to assist Convocation is to start with the existing regime so that you understand it and then the change. The blackline version of the rules is at page 50 and following of board books. And there are essentially, with respect to retired judges returning to practice, as the rules currently stand, two categories of judges. The first currently is the category of judges who were formerly judges of the Supreme Court of Canada, the Court of Appeal for Ontario, or the Federal Court of Appeal. And the essential rule is that those judges are not entitled to appear as advocates, as counsel before courts and tribunals, unless they seek and obtain permission to do so, which is not to be the normal course. Currently, the second category of judges are those sitting, or who sat rather, as retired judges in the federal court, the tax court, the Supreme Court of Ontario, trial division, the county or district court, the Ontario Court of Justice, or notably for today's purposes, the Superior Court of Justice. For those retired judges, if they wish to appear as advocates or counsel in the first 3 years after they've retired, they require permission just as the appellate judges do now. But after 3 years, they are entitled to appear. As you'll see from the report at board books at page 48, a request was made for an amendment by Associate Chief Justice Morocco on behalf of the senior executive of the Superior Court. And the essential request which has been made is to move the Superior Court judges or retired Superior Court judges from the second category to the first category so that they would have the same requirements as the retired judges from the Court of Appeal of Ontario, Federal Court, or Supreme Court of Canada. As you'll see at paragraph 6, the issues of the integrity of the court have been raised, and you'll see in 6A that some judges who have served at the same time as judges before whom they appear that situation has given rise to the sitting judge having discomfort over presiding. Some judges have recused themselves in the circumstances. We understand that other judges have given an indication that they intend to recuse themselves in the future. There is a concern about newer judges who hear submissions made to them by judges who sat before they were on the bench themselves, and that has apparently given rise to some discomfort. Leaving aside, but not disregarding at all, the concern of the sitting judge, there is the concern of the parties before the court who are concerned, one can imagine that a prior judge is making submissions against them to a court on which they sat. And one example which highlights this is, I'm not suggesting that it's common, but it highlights the point, is counsel referring not to my friend but to your honor when dealing with the submissions opposite.
Laudable practice.
Yes, Your Honor. The other difficulty, of course, is dealing with case law and jurisprudential submissions, citing one's own case as a precedent, and surely, as well as being unseemly, makes it difficult for the judge and the parties to assume that this is being dealt with in the ordinary way. And equally, the concern is raised that if a judge's prior decision is against the client's position, it may be more difficult for the judge to argue that position. Finally, it is noted that the fact that there have been and are likely to be more recusals is likely to cause inconvenience and delay in the administration of justice and, of course, increased cost. So, the essence of the motion is to change the categorization of the retired Superior Court judges. The question raises, because you can tell from the examples given that one might have a broader application of this, or one might consider it. What we haven't done yet is go out to the other courts who are in the second category. We think it appropriate to make inquiry of the Ontario Court and the Federal Court, the Tax Court, to see what their views are. We could have, and in some circumstances would have gone out to them at the same time. We did not do that because of the concern for timely change as to the Superior Court. We were asked to deal with this in a prompt manner. And of course, one can imagine that the other courts might have wished earlier to be involved in this, and they've expressed that concern, and the Treasurer has expressed our apology for not involving them earlier. Nonetheless, the Superior Court is the court which currently has the issue. We're told, at least by one other court, that we will consult further with, that they don't perceive an issue or don't have this practice practically for them. So that's the go forward. The go forward is to look at the other courts and to obtain input. Nothing today forecloses anything with respect to them. The motion is only with respect to Superior Court. A tag end matter, which is of no policy significance, but nonetheless is an amendment requested. The permission which is required under the Category 1 set, and as well a parallel framing in another rule, refers to permission being granted by a committee of convocation established for these purposes. And while this is before my time, and I frankly don't know the policy reasons behind it, the Committee of Convocation is the panel of the hearing division as it's currently been set since 2007. It is proposed that the rule be amended not to change the process, but to make the process clear so that it refer instead to a panel of the hearing division. As I say, that's not a substantive change because that's the policy now, the practice now, since 2007. Some have asked whether or not that's the right practice, and if the will of convocation is for us to consider that, we can do that. All we're doing now is truing up the rule with what actually happens. So subject to questions and obviously views of others, though that is the motion.
Okay, I have a number, okay. I think the first person I had was Justice, excuse me, the Honorable Mr. Spence.
Thank you, Treasurer. When I asked to speak, I guess I should go forward.
Yes, if you could go to the podium,
Yes.
please, so it's picked up for the.
Mr. Armstrong tried to trip me there, but it didn't. I didn't appreciate when I asked to speak that Mr. Armstrong was also going to speak. I've learned from past experience that I should defer to him. He is, after all, the senior retired judge, and his last name starts with A. So, I've looked forward for some time to the opportunity to make my first remarks in convocation in this century. And, being here now, I think I have to say that I rise to speak in order to say that I do not wish to speak. I think this is a matter, in my judgment, that is best left to convocation and should not be complicated by any notion of a conflict of interest. I don't think I have any conflict of interest. The occasional practice of mediation and arbitration, which I have at the moment, occasional underline, does not constitute the practice of law, as I understand it from the Law Society. So I don't think I'm conflicted, but somebody else might think that I had no business taking part in this, and I don't want to get into that argument. So I propose not to take any position in this matter, and I won't vote on it, unless, of course, Mr. Armstrong makes submissions that change my mind.
Okay, Mr. Lerner was next. And followed by Ms. Leeper.
Very briefly, I have two questions, very brief questions, and one comment. The first question is, I notice in the definition section that exceptional circumstances has not been defined. Is that deliberate?
It is deliberate in the sense that we did not wish to change the regime, but merely to move one category to the other. That has been the existing rule, and frankly, it does not seem to create problems. If the will of convocation is that we should go back and examine that, we will. But this is intended to be the least amendment possible to achieve a purpose.
My second question is it intended that this new rule be grandmothered?
The intent of the proposal is that this apply to judges who retire going forward.
And my comment is, the discussion that we've had today seems to be focused primarily upon the profession and conflicts that may arise within the profession. I think we cannot forget the public perception of the practice, where on one occasion an unrepresented litigant appeared before a deputy judge of the small claims court, and the other party was represented by a retired Superior Court judge. I just regret what would have happened had the media walked in on that day and what the public's perception would have been as to the fairness and the integrity of the administration of justice. So I wholeheartedly support this change.
Thank you, Mr. Lerner. Ms. Leeper, followed by Mr. Armstrong.
My question has been asked and answered. Thank you.
Mr. Armstrong.
Thank you, Treasurer. I fully support this motion. I thought, if for no other reason, that any rule that keeps the former Treasurer, Mr. Spence, out of the courtroom has to be a good rule. That said, I don't support it on that basis, although I welcome it. It makes absolute sense. Former judges should know their place, and their place is not in the courtroom.
Thank you, Mr. Armstrong. Mr. Faulkner. Followed by Mr. Wright, and then by Mr. Galati.
I support the change, but I must say I support the change with the following caveat, Treasurer, and it's this. As we confidently recognize the problem inherent in former judges appearing before the courts, I think we have to reflect on our role as benchers in the hearing process, including the prominent roles of many benchers as appeal panel writers, and whether or not we have to be very careful to understand as we adopt this, the sauce for the goose and sauce for the gander applies to our role as judges. I'm raising this because as we approve this, I don't want to hear my colleagues say, oh, it's a different rule for us, because when we're judges as benchers within the Law Society framework, we retain the right to appear before panels of the Law Society down the road when we're not benchers anymore. I just raise this because it's absolutely essential that we make this a level playing field where we recognize the difficulty inherent in judges appearing before tribunals or courts in which they've been judges, and that includes us. So I do support this. I think we have to be very careful to respect the fact there is a group of people that will, small as it is, that will be affected by this because of the retroactivity of this, and that we may want to consult with those folks with a view to at least being respectful of the fact we just took away their right to practice in a courtroom. So I do support this. I think we have to be careful to realize that there are two sides to these discussions and that there are ramifications for us all. Treasurer.
To be clear, there's a right to apply. It isn't taking it away altogether.
Right, but I see the exceptionality provision. So
Yes,
the message to me is there's a right to apply, but unless you fall in some extreme circumstance, you will not qualify. I look at remote communities.
I just want to clarify for the record.
Yeah, I look at remote communities and I look at other realities. I, again, support this rule. I just want us all to recognize that there are ramifications for this across the board.
Next is Mr. Bright, followed by Mr. Galati.
Thank you,
And
Treasurer.
followed by Mr. Anand.
Thank you, Treasurer. I have a quick question. Does the phrase "as counsel or advocate in any court," is it broad enough to include amicus curiae, or should that be added as a third item?
I don't know. And what we've tried to do, as I've indicated, is to do what can be done easily without change, to simply move one category of judges, or one set of retired judges, from category 2, as I've described it, to category 1. We haven't done a rethink as to whether or not the rule and all of the language in it is appropriate. I would simply note that it doesn't seem to have caused any problem. If we need to, we can go back and look.
Okay. Mr. Galati.
Very briefly, Treasurer, I support it too, but for my liking, I think we should think about removing the right to apply as well. I don't see how any former judge appearing in a courtroom vis-a-vis opposing client could ever pass the Mackin test from the Supreme Court of Canada that there is a reasonable perception of independence and that there is no interference by either the legislature or others in that courtroom. I don't see a judge appearing in court ever passing that test. Thank you.
And Mr. Anand.
Treasurer, through you to Mr. Mercer, I support the substance of what's being proposed. I have a procedural question with respect to the issue of taking the matter from a committee of convocation appointed for the purpose and moving it to the hearing division. And it applies to both of the circumstances that are proposed here. One is the retired judges that we've been talking about, and the other is the issue of a person who's under a licensee who's under suspension seeking to work for a licensee who is in good standing during his or her suspension, or indeed after revocation. And in both cases, the proposal is to move it from this sort of amorphous concept of a committee of convocation appointed for the purpose to a hearing division hearing, I take it. And I've participated in one of the second category, that is sitting on a committee in which the issue is whether a licensee who's not in good standing can work in a law firm, for example. And there was some question as to what the nature of the procedure is. And I raise this because it's not clear to me who the parties are in either of these cases. The retired judge can make application, and he or she is subject to the criteria of exceptional circumstances. It's not clear to me whether the Law Society is a party to that, or it's simply the retired judge before the hearing division on his or her own. in the situation of the law firm and the suspended licensee, it was the managing partner of the law firm who came forward and said, we would like to hire X, and the Law Society objected, and so while it wasn't a hearing, it was a conversation around a table essentially. The Law Society was taking an adverse position. It's not clear to me exactly what the procedure is and what the Law Society's role is here.
Mr. Wright is able to answer that.
Oh, I'm sorry, I was reading. Wrong, Mr. Wright.
If Convocation passes this, the intention is that rule amendments would be brought to the Tribunal Committee very shortly that would address those issues.
Thank you. Are there any other questions or comments in the room? Ms. McDowell.
No longer in lecture mode.
Can I just ask Mr. Mercer to clarify the retrospectivity point?
The intent is that this amendment apply to judges who retire now and going forward, but not to judges who have previously retired.
So it won't solve the problem, I take it, that identified by Mr. Lerner.
Yes, it is not, if Convocation is of the view that we should consider and address the issue of existing retirees, we can do that. But the intent of today is to put in place a rule for those who have not yet retired, so as to be clear and prompt.
Okay, any questions or comments on the phone? Sorry, we have one more in the room. Ms. Potter.
Yes, I'm just going to stand here
Oh.
briefly and ask.
Could you talk loud then, really loudly?
With respect to Mr. Galati's point about why are they allowed to do it in the first place? Why are they? I mean, to me, it is wrong.
Let me, this allows me to give a unpaid announcement for the Federation of Law Societies Canadian Bar Association Ethics Forum in the first week of March, where we'll be having a panel of academics discussing exactly this. And I would invite you all to come to see why Ms. Potter is probably right.
All right, any questions or comments on the phone or any more in the room? Oh, Ms. McGrath.
So Ian and Derry are here. Can we do this after the break? Yes. Right after.
Treasurer, I'd just like to express my concern that if this only applies to judges who retire from this point forward, that this is not going to solve the problems that identified by Justice Morocco, because he's indicated that it's an existing problem in the Superior Court right now. So I would suggest that we ask the committee to look at extending this to judges who've already retired as well.
If that's the will of Convocation, and I sense that there are those who think that that should be done, it seems to me appropriate that we consult as well with the existing retirees and indicate that we are considering the possibility of a rule change so that we have the benefit of their input as well.
Well, perhaps it should go to your committee first for discussion. And
of course.
Yes. Mr. McDowell, Mr. Faulkner.
Could I suggest that we pass the amendment today as a starting point and then
Yes.
remit the matter?
Yes, that was the intention. Okay, Mr. Faulkner.
Yeah, just from here and loud, could I ask that the Convocation consider referring also the question that I raised as to what position it puts us in as Law Society judges, Law Society tribunal judges, and ask the committee to consider that as well?
You'd have to ask the Tribunal Committee, I would think, to address that.
I suggest it's probably an intercommittee issue, but because this committee has the issue, it's a shame to split it up. I think the issues go hand in glove.
It's in the code of
Okay, I have at the moment Ms. Alexandros and Mr. Brett, and Ms. McGrath was first. Sorry, you've done that. You've spoken. You don't have something more.
No.
I've got you. Okay. All right. Then next is Ms. Alexandros. Sorry. And Sarah Papa Giorgio? That's gone. And Mr. Brad? Sorry. Yeah, sorry.
If we're gonna be remitting things, I think we should also remit the question that Rocco Galati raised as well.
Thank you.
Mr. Brad?
So I just rise to note that the question of appearing before administrative tribunals, of which you were a previous member, is somewhat more complex. It is frequently the case that people might sit on the Ontario Municipal Board or the Labour Relations Board and thereafter return to practice. So I'm not sure that we should single out the Law Society. If we're going to look at the issue, it's a much broader issue dealing with the administrative tribunal system as a whole. And I'm not sure that the considerations involved before the administrative tribunals are exactly the same as the considerations certainly involving Superior Court judges.
Just so people are clear, and I think this is Mr. Anand's point, the tribunal has in the code of conduct for adjudicators addressed this issue. Whether that should change or not is a different matter, as there's a cooling off period as opposed to a prohibition, but there is provision for this.
Okay, any questions or comments on the phone? In that case, we'll take the vote. It's for the motion moved by Mr. Mercer, seconded by Mr. Shabas.
Sorry.
Okay, all in favor? Any opposed on the phone? Motion carried.
Thank you, Chair.
Thank you.
The conference is in lecture mode.
I think we'll take our morning break now, and the next item when we come back from lunch will be from the Audit and Finance Committee.
That's fine.
Okay, welcome back to part 2. Our next item for discussion will be the report from Audit and Finance. Mr. Wardle.
Thank you, Treasurer. So the motion for decision is at Board Books at page 343. Relates to the Lawyers Feed the Hungry program, and let me just give an introduction to the motion, which is coming from Audit and Finance, and 2 of the trustees of the Law Society Foundation, Derry Miller, and Ian Hall are here, and I know Derry in particular is going to speak to this matter, and Ian is also available to answer questions. So I think everyone understands that the Lawyer Feed the Hungry programs governed by the Law Society Foundation and administered by the Law Society are very much needed in supporting a number of communities across the province. This motion really is intended to extend the in-kind support provided by the Law Society, and as well to provide financial assistance with fundraising and stakeholder management to all 5 of the hunger relief programs currently running in Ottawa, Toronto, London, Windsor, and Barrie, which right now have separate fundraising initiatives and stakeholder management. I want to just give you a little bit of the background, although I'm sure everybody's read the materials. First of all, Law Society Foundation, different than the Law Foundation. Took me about 4 years as a venture to figure out the difference. The Law Society Foundation is a registered Canadian charity administered by the Law Society, and it's essentially the charitable arm of the Law Society. Virtually all of its trustees are benchers, so the current trustees of the foundation are Ian Hall as chair, and benchers Mike Lerner, Derry Miller, Kathy Strasberg, and Sid Troyster. The Law Society Foundation has funded the hunger relief program since 1998. As I think most people here know, the Toronto program was initiated and originally operated by the Toplitsky family. The legal profession and the province owe the Toplitsky family a debt of gratitude for their immense contribution to hunger relief. Those programs have grown significantly since then and have expanded to include programs in 4 other Ontario centres. The current scale of the programs is documented in your material. The foundation's expenses for the Toronto program alone exceeded $400,000 in 2015. All of the hunger relief programs are funded purely by donations, which recently have roughly matched annual expenses. In-kind resources are provided by volunteers and by the Law Society. The program serves meals to over 60,000 individuals in need every year. There is a significant component of in-kind support provided by the Law Society, which includes staff resources, members of the staff who actually volunteer, provision of food from the kitchens, etc., assistance with administering the finances of the organization. We are at a point, if I can put it that way, where the trustees have concluded that Lawyers Feed the Hungry has a real need for some professional assistance in fundraising and stakeholder management coordination dedicated to support the program. The estimated cost of this, and we're really talking about an individual who would be employed to carry out these activities, is $100,000 a year. This request first came to Audit and Finance and was approved by that committee, obviously, and is now before Convocation in the form of this motion. You'll see when you look at the motion on board books that it has some fairly careful parameters placed on it. It says very clearly that the money is to assist the Toronto program in particular in moving towards a self-sustaining model over 2 years. And this is a 2-year commitment. It's not an indefinite commitment. But I should tell you the downside of this is that this will be another item that is funded out of the current year's contingency, $100,000, because it wasn't included in the budget during the normal budgeting cycle. So after this morning, we will have eaten into the, assuming that this motion is carried, of course, we will have eaten into the contingency for 2016 by $350,000. Before I turn it over to the trustees, I just want to make a couple of additional points that are not found in the written materials. First, I want to make it clear to everyone that we are not looking at a new initiative in determining whether this fits within our regulatory mandate. This program has been running for 18 years under our umbrella. It is publicly identified with the Law Society. It is a public relations success story for the Law Society, and it is supported by many people around the Law Society, including a number of staff and a number of benchers. So the question in my mind is not whether we continue to support Lawyers Feed the Hungry, it's in what fashion. Second point I want to make is that when I talk to people about Lawyers Feed the Hungry, I think a number of us have the perception that it is actually some external organization that we're dealing with. No, it's not. It's our baby. We created this baby, we have fostered it for 18 years, and the Law Society Foundation Board of Trustees is made up of people, with the exception of Ian, who are people who are in this room, part of the bencher complement. So, like anything coming from one of our committees, the current motion started with the trustees who are wrestling, I would say, with the problems of how to deal with Lawyers Feed the Hungry down the road. And I think everyone should just appreciate that it is, in fact, part of our organization, and we already have really a subgroup of the benchers who are dealing with some of these very difficult issues. So that's my introduction to the motion. I don't know if Derry or Ian, Derry's right behind me.
I was going to call on Mr. Miller first.
Thank you very much, Treasurer. I'd like to start by saying that in 1998, when the Lawyers Feed the Hungry idea came to this convocation, the issue was debated as to whether or not the supporting this program was within the mandate of the Law Society. Nobody said it was within the mandate of the Law Society. What we did say, and what I said in one of the speeches I gave, was that this was an activity to be supported as a good corporate citizen. As a good corporate citizen. And the society has supported this over the last 18 years as a good corporate citizen. And as actually, as Mr. Wardle has said, attracted a lot of very positive publicity, and it's enhanced the reputation of not only the Law Society, but lawyers. For many, many, many years, as Mr. Wardle said, the Toplitsky family, in effect, looked after the fundraising, etc., for the Lawyers Feed the Hungry program in Toronto. The Law Society Foundation did the receipts, organized the receipts. The Law Society staff organized the kitchen, and so the Law Society's been intimately involved. Starting in about, I guess, in 2013, when, or a little earlier, when Mr. Toplitsky was withdrawing in part from the program, the trustees, along with the volunteers, turned their attention more to fundraising. And there are people in this room who have initiated fundraising activities and have raised a lot of money, Jonathan being one of them. And for lawyers.
Rosenthal, you were referring to, just so we have it
Yes.
for the record. Thank
Yes.
you.
And what's happened is that the program and the programs across the province, because the funding for this position will support the programs across the province. And it's one of the things that this person is going to do is to do stakeholder relations. One of the things this person will do will work with on fundraising. Part of the problem, Ian is the chair. Ian is a volunteer. He's not a bencher, he's a volunteer. He has been involved as a volunteer on the Law Society Foundation for, I don't know, a long time, 10 years, and has been intimately involved in working with the Lawyers Feed the Hungry program. Mr. Hull gets every day, every couple of days, fundraising ideas about ways to create money, get money. And part of the problem is Mr. Hull has actually got a day job. And one of the things that we hope that the person who's retained to work on this job for the next 2 years will take some of these ideas and work with the trustees to bring them to fruition so that we can make this sustainable. We're not setting out to set up a charitable foundation with right from scratch. We do have, and we raise about $150,000 a year right now, and we just need to build on that. Now, one of the concerns is that this money will just be used for Toronto. Actually, the money will be used to support the programs elsewhere. There's an issue that some people have raised that's, while it's Toronto versus outside Toronto, the one thing, the money, as I said, will be used outside of Toronto. But there are many, 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 many things that are funded by the Law Society that apply not only inside Toronto, but outside Toronto. For example, the library levy. The towers pay $200 a year to support the county and district law libraries. The tower, how many thousands, 10,000, 15,000 lawyers in downtown Toronto never use that system. But it's part of our responsibility as members of society to pay that portion of our dues. And there are many other programs we could talk about that may be focused here, focused there. And it's this money will be used across the province, but frankly, it'll be used principally to support the Toronto program over the next 2 years. It's one of those things that you should know. The staff, the Law Society has been, I don't know how many years now, as #1 employer in the top 100 employers in Ontario. And the Law Society staff have been tremendous supporters of the Law Society Feed the Hungry program. Not only the finance staff who work long hours and more hours than necessary in their job to support this program, but the volunteers, the staff who volunteer in the kitchen, who volunteer to serve meals, and to raise money. There's a substantial amount of money raised by the staff of the Law Society of Upper Canada to support this program. And all of these things build morale in an organization. And we're not asking for an open-ended check. We're not asking to say, do this forever. We're asking for 2 years. And it's a program that is worthy of support, and it's a program that I urge you to support with this money. And I'd be happy to answer any questions, as would Mr. Hall.
Thank you. Mr. Hull, do you wish to speak now or later?
Three quick points.
Please.
Thank you for allowing me just to speak. First of all, I really do firmly believe we can do this in the 2 years for what we're asking in terms of resources. We are in with both feet, we know that. And as my dad used to say, we just need to give this one good college try here. And the institutionalizing the fundraising is already there. We're probably 25% there already in terms of process, in terms of stakeholders and so on. We just need help and support just to lift it up, because as we always know, we need $360,000 a year in the Toronto program, and we need support in the other programs because of the fact that the Law Society is really running it on the side of their desk as best they can. And the last point is that the key to this is going to be the awareness. I cannot tell you how excited I get every day about the awareness that has grown just from the fact that we're bringing this to the attention of the profession, because I think across Ontario, every single Toronto lawyer, every single lawyer in London, Ottawa, and Windsor, all of the areas, and Barrie that's looking into it, every lawyer, when they hear about it and they understand the program, it becomes one of the top 3 choices for charitable giving almost instantly when they understand what it is. And so this person can help us get the awareness up within the profession, and that's where the growth will come, and that's where the institutionalizing will come.
Well, before Mr. Hall sits down, one of the things that we do have, and this person will work with, we do have a volunteer fundraiser, a professional run fundraiser who's helping us. And the person who would be hired would work with our volunteer professional fundraiser to, as Ian said, deal with raise stakeholder awareness and help raise money.
Okay. Any questions or comments on that from the room? I have first Mr. Lerner, second Mr. Faulkner. I'm adding Mr. Callahan. Ms. Vesbury, okay, and Ms. Murchie? Okay. Mr. Lerner.
I am one of the trustees. I think you need to know that the programs in London, Barrie, Ottawa, Windsor are in good shape, and they are able to, but by the manner in which they have set up their programs, have supported and will be able to continue to support the local Lawyer Feed the Hungry program. The problem, and I have said this to this body on a number of occasions, is with Toronto, and I think that you've heard optimism I too am optimistic, but with some reservations. The success of this program is going to depend primarily upon the lawyers and the support that the program gets from lawyers in Toronto. I think you need to know that the Law Society's contribution is extensive, to the extent that there is one employee who works Friday nights till 10 o'clock and on the weekend because she can't do her work because of her commitment to this program and the things that are asked of her. So I look at this as, you know, spend a little, save a lot. If we can get our staff disengaged, except on a reasonable volunteer basis, if we can get this individual that we're talking about to do what we hope he or she can do, the program has an ability to survive. After 2 years, it'll be time, as the proverb says, to fish or cut bait. And the program currently has enough money to get us through to that stage at its present level, but not far beyond that. The question is, really up to now, who's in charge? It's been identified as Mr. Teplitsky's baby, and the support of the Teplitsky family is just incredible. But there's no formal structure that is in a position to be the succession plan for the Teplitsky family. We are hoping with this individual that there will be a structure implemented, that there will be outside independent fundraising, that the current support in kind of the Law Society will be significantly reduced, and that with the cooperation and support of the people, not only in this room but across the province, this very worthwhile program will be able to continue. I think, I don't know whether Mr. Lapper wants to talk about the extent to which the Law Society has supported this. As I see it going forward, if we are successful, the Law Society will simply be in a background position. The foundation, the structure will be in place so that we will be called upon simply to administer through the foundation what is appropriately within our area of expertise and responsibilities. And those people who believe in the program will be the people who move forward with it, hopefully indefinitely.
Thank you, Mr. Lerner. Next I have Mr. Faulkner, followed by Mr. Callahan.
Treasurer, I rise to, first of all, support the initiative. I've spoken to why on previous occasions I think this is an important program, and was met with some of the concerns Mr. Lerner just expressed, but I think Mr. Miller raises a very good point that what is now being proposed has the benefit of not just helping the Toronto program, but actually having a coordinating impact across the province. I was extremely lucky to be part of our Volunteer Ventures program yesterday to participate in Feeding the Hungry. I'm embarrassed to say that it was my first time. I'm ashamed that I never showed up before. To describe it in terms of personal experiences, I would say that I commend each and every one of you to participate just once. It really, really makes a difference to the people you're helping. The environment all of a sudden is transformed from what could be a very negative feeling to the most positive. Lawyers, we marvel at how important we think we are, and the public marvels at how much they dislike us. And never the twain shall meet. And in that room, when we're feeding the hungry and we're treating them with respect, there is a meeting. And lawyers are appreciated as people. So we get more out of it than they do. Derry, Ian, Amanda Ross, the volunteer coordinator yesterday. These people are doing huge work. We should all be indebted to them, and our job is to support it. We have the money. Let's be honest, we have the money. I understand that stewardship of finances is key, and I'm not in any way suggesting we be irresponsible in that regard. But this is a pure good thing. There is nothing about this that is other than good. And so I commend you, Treasurer, for leading the initiative to get benchers out. I think we should institutionalize that effort. In other words, I think there should be a regular group of benchers that attends every week. It's the right thing to do. It's the right, and it's great. You can make it when Convocation happens. You can make it once a month. But I'm saying this to you, I'm a convert. But I really want to give tribute to people like Amanda Ross and her team that we saw yesterday, because truly this is a special thing that they do, that we participate in. We need to support it. Thank you, Treasurer.
Amanda Ross is a volunteer lawyer from the City Legal Department. Okay, Ms. Vespri, you're next. Oh, no, I'm sorry, Mr. Callahan and then Ms. Vespri, sorry.
I see it as a rather simplistic issue. For 18 years, 60,000 people in Toronto have come to our door to be fed. 60,000 a year come and ask for sustenance. You know, we've got a lot to give as lawyers. Here, we're giving our facilities, and now we're being asked to put this program on a stronger financial footing. When I got involved at the fundraising end, Joe Newberger, who was Ian's predecessor, who has done yeoman service like Ian on behalf of this program, talked about Bolaramas. And I said, you gotta be kidding me. We're feeding 60,000 people on Bolaramas. You've got to be out of your mind. And yet that's what they did. They benefited because over the years, generous plaintiffs' counsel and class actions were able to obtain side payments out of my clients and fund this program. That's not happening to the same degree. And if it's the decision of Convocation to roll up the red carpet, turn our fellow man away from the door, then you better think about it now, because there's not going to be sufficient money to do it, and those people have to go out there and find someplace else to get 60,000 meals. You cannot set up a structure and walk away from it. When I got involved, and I'm not that involved, I do de minimis type effort work, as I usually do, but I tried to sort of say, like, why don't we get some corporate sponsors? And I was able to bring at least two or three corporate sponsors whose names, if I gave you to, you'd recognize, some in the food industry. And I got them to a point, and I couldn't close the deal. I could not close the deal. I'm as good a fundraiser as I'm a lawyer, and I lost. But it turned in my mind that we needed some, and we actually, Ian and I, to the very generosity of the Liberty Mutual insurance company in Canada, have come forward, and they're starting to participate. But we need to get this on a sound footing. And if lawyers are not going to donate, we've got an obligation to see if we can find others that can. And these people who were asking you to take 2 years of a flyer at $100,000 to put this program on a sustainable footing are those that can help us hopefully cross the Rubicon. And if we don't cross the Rubicon, we in this room can figure out how we tell 60,000 of our fellow man and woman and child where they can go get some food.
Thank you, Mr. Callahan. Ms. Vespri.
Thank you, Treasurer. I appreciate the size and benefit of the program, saying that it feeds 60,000 people a month. Clearly a huge effort and a year. Sorry, okay. Lots of people over time. We'll be vague. But that argument also comes around to sounding very much like it's too big to fail. We can't let it go because it's big. It's big because we can't let it go. It seems quite circular. I have some questions, I guess to the Finance Committee through you, Treasurer. At the beginning of the month, when we all went to committee meetings, we were all given, or every committee had the same list of our strategic plan, our strategic ideas that we were to carry forward in committee. It was published to the public in our lovely graphically designed pie chart, and I do not remember seeing anywhere in that lawyers feeding the hungry. If we are talking about our budget is tight, we may have to look at programs that we might have to drop. A program that did not make it into the top mentions at our strategic planning, I'm not sure why at the beginning of the new year we are committing money to that when it wasn't even discussed, when it wasn't something that we had a chance to talk about when we were doing our strategic planning. That's when it should have been on the table, not now. I'm concerned by the process. It seems to me peculiar that individuals, benchers and non-benchers, can walk into the Finance Committee and say, oh, by the way, we'd like $100,000. Without that coming from any committee, without, as far as I know, that coming from you, the Treasurer. It might have done, but that is not apparent. It looks like walk in, ask for money, sounds like a good idea, we'll give it to you, and now it's in front of Convocation without any prior discussion, without any chance to discuss not just whether this is a good idea. Of course it's a good idea. It's motherhood and apple pie, or motherhood and poutine, whatever it is in Canada. There's no way that anybody should say it's a bad idea. But is this the best way to spend the money? In most of the other cities where there's a Feed the Hungry program, it's done with a mission. It's done with another organization that already exists to feed the hungry the other 5 or 6 days a week. Because if you're hungry every day. You're not just hungry once or twice a week, or however many times a month, or however many times a year. Those 60,000 people need food every day. And if we were giving that money to a food bank, to a series of shelters, to other organizations, could they use it more with a better rate of return, if you like, than we can? They have the structures already. They have economies of scale already. They don't need to pay somebody $100,000 for a year of fundraising because they already have their fundraising in place. What are we adding to this? We're adding our name. We're adding half our name. It's Lawyers Feed the Hungry. This isn't coming out of lawyers' fees only. This is coming, as far as I can tell, from our general budget, which means that the name at least should be Lawyers and Paralegals Feed the Hungry. And it's not. Licensees Feed the Hungry, or the Law Society Feeds the Hungry. Whatever you want to call it, Lawyers Feed the Hungry is denying part of our membership the fact that some of their money is going into this as well. I'm curious why the Law Society funding group went from, according to the documents that we were presented, went from funding students and scholarships. I'm not sure whether that is still happening. Again, with the financial crisis that students are facing, with the increasing costs of bar exams and entry into the profession, is this the best way we can spend this money? As a charity for lawyers, to excite lawyers, to get lawyers involved and paralegals involved in funding this. Because quite frankly, if it's lawyers feed the hungry, but it's actually big corporation X feeds the hungry, I'm not quite sure what we're doing here. Why doesn't big corporation X just feed the hungry if they want to? There are so many different things that people can volunteer to do. If volunteering at a food bank is a life-changing experience, food banks look for volunteers all the time. And you can volunteer in them in any city you please without having to come to Toronto to do it. I don't see the financial justification of this. I think that we are being, perhaps in a lawyerly way, somewhat arrogant, believing that we can do a better job than the people who do this 24 hours a day, 7 days a week, 365 days a year. We heard earlier today discussion of prudent spending. Prudent spending, to my mind, requires an evidentiary basis of why it is prudent, why it is cost effective, why this alternative out of many alternatives is the best one. I would love to see that evidentiary basis. If it actually shows that this program is the best way that those 60,000 people can be fed, I'm happy to vote for it. I think it's a grand idea. If it is more about egos and people being able to say, gee, I did a good job today because I volunteered, then I really don't think that that's a way that we should be spending our members' money. And I'm very leery of the fact that we're now going over a third into our contingency fund in the first month of the year. Thank you.
Thank you, Ms. Vesbury. In view of the fact that as I indicated, I need to take a short break, we'll do that. I have yet Ms. Murchie, Mr. Murray, Mr. Brett, Mr. Rosenthal, and Mr. Galati. So again, I'd ask you to not raise new things necessarily, but I don't want to cut this unnecessarily short. So I shall return in about, hopefully, 5 or 10 minutes. Thank you. Thank you. Could we continue with the speakers list? Ms. Murchie is next.
Thank you, Treasurer. I should say that the remarks that I have notes on have been vastly reduced by Ms. Vesbury's comments because she's echoed a number of the reservations that I found myself having. But I do want to speak to two particular points. And it's not because I think this is a bad charity or because I think that this is not a worthwhile initiative. My concern is with the evidence that we have on which to make this decision, or I should say, the lack of evidence. My concerns are twofold. First of all, I don't believe that the Law Society has the expertise to take on this role. And I don't think there's any evidence that we do. And secondly, there's no evidence that this proposal is the best choice. There's no evaluation of the efficiency of the programs or of how we deliver them. So on the first point, I do want to say that and I'm sure many of us have sat on charitable boards, the charity world right now is a very competitive world, and fundraising is not for the faint of heart. And though I appreciate that adding a fundraiser will certainly add some capacity, I'm not at all satisfied that we have the basis, the business basis on which to hand over $100,000 without some further evidence. We don't have expertise in this area. We're a regulator. And although we've been helping and providing in-kind services, and I understand administrative services, and I'm told the number I heard was approximately $200,000 a year in-kind services, we're now being asked to also fund a fundraiser. And we don't have any experience in supervising or in fundraising or in setting up a fundraising department or in doing the kind of fundraising that will be necessary to support this endeavor. It seems to me that we need evidence that this is the right way to go. That in fact, the Law Society's operations, to the extent we have them now, are efficient and appropriate, and that adding a fundraiser will provide the necessary additional forces to allow this program to be fully functional. We haven't got any of that evidence to explain the basis on which the foundation says that we should proceed in this manner. When I look at the budget that's been presented to us, and I think about the in-kind services, I think we're looking at running a charity here that's approximately in the $1 million a year range. And that is not an insignificant undertaking. Clearly what's been going on to date without leadership, as was discussed, is a really valiant effort by some very dedicated volunteers to make this work. And they have to some extent, but it's no longer self-sustaining. And it's reached a point where some infrastructure has to be put in place. And that infrastructure is going to cost some money, and I am not satisfied that we have the evidence to support the particular infrastructure that is being proposed. The second point is that it seems to me that we don't have any evidence that this is likely to work. We heard Mr. Miller and Mr. Hull talk about it's hoped that within 2 years we'll be on our feet, that kind of thing. But we don't have a business plan. I mean, there are consultants in the not-for-profit world that could put together facts and figures that would support this proposal. I'm still concerned that there's a lack of leadership, because leadership by a board is very different than leadership by a CEO of a charity. And it's just not clear how that's going to proceed in this way. So this program has found itself in a position that's not uncommon in charitable operations, and that is that the services that they want to provide and or do provide are not supported by the fundraising. And I would like, as a bencher, and I think all of us, should require some better evidence to support the proposed course of action, and some better evidence that the alternatives that are described, including partnering with a local organization, would not be preferable. We don't have the expertise, and we should not pretend that we do. We should look at the other alternatives, and or the foundation should provide evidence that the route they propose is likely to be successful before we vote on extending this further money to them. Thank you, Treasurer.
Thank you, Ms. Murchie. Mr. Murray.
So I was listening to Barb speak, and I noticed that she had lots of notes, and it reminds me that Ian Scott used to tell me many years ago that, Ross, when you're appearing in court, you need notes. You can't possibly remember everything. And later, when I became a bencher, his brother, David Scott, told me the same thing. But this morning I'm here with no notes, because I didn't intend to speak. But I have to say that I think this is a topic that needs a lot of thought. And first of all, I speak as a life bencher, first elected in 1991, and as a bencher from Northwestern Ontario. But the fact of the matter is, we have been talking about Feed the Hungry for 18 years. I remember when Nancy Backhouse and Harvey Strasberg first brought it to Convocation's attention, and it seems to me that the Feed the Hungry program is actually part of what we do at the Law Society. I mean, after 18 years, I think we have to accept that that's something that we do. Now, back in 1995, I was the chair of finance, and we were going through some rough times. And we used to go through the budget line by line. Now things are better, and we don't do that anymore. But you know, what we really need to do with the Feed the Hungry program is we need to incorporate it into what we do. it needs to be a department, like catering or some other department. And it needs to be considered as part of the budget. I mean, we can't really say, well, we're not going to fund the Feed the Hungry program anymore. That's out of the question. It's part of what we do. And I say that as a venture from Thunder Bay. We have really no connection in Thunder Bay with what happens at Osgood. But, you know, we have a shelter house in Thunder Bay. Our new status of women cabinet minister ran it. My wife is a volunteer. And I've gotten to know people that are hungry every day, families, children, mainly men, I don't know why, and at least at this shelter. And it's important, it's part of the makeup of what we do. And I think for the Law Society, we have to accept this, it's important, it's good, and I think we just need to make it part of what we do. Put it in as a budget item, and fine, we pass this motion, we try and raise money, but I think basically we fund it.
Thank you, Mr. Murray. I'm looking at the time. We have 5 people on my list now, and I haven't canvassed the phone. We have other important matters to deal with today, so I ask the following list to please be concise. Yes, Mr. Brett.
Stay there, you're on camera.
Thank you, Treasurer. So I rise to support the motion. And I do so despite the fact it's out of our mandate. But let me explain why. So again, I start off with a proposition that we're here to regulate the profession in the public interest and forward access to justice. This is not a charitable organization. I'm involved with a program that we work called Lawyers Read to Kids. We go into inner city schools and we help kids learn to read. And I'd be delighted if the Law Society was going to provide us $100,000 in funding, because we could expand the program tremendously, and I could take a lot of your time to tell what a great job we do. But this is not access to justice. This is a very good cause. I've been there a number of times. I support the program. I think it's a good program. I just think that this is not within our mandate. What's happened here is this program got put in place by good intentions, and I think that we have to support it to make a transition. What happened here was there was a program that was relatively sustainable, and as a result of several large CPRE awards, it expanded. And unfortunately, it's expanded to a level where it's no longer sustainable. And what happened? The CPRE awards, which came to Lawyers Feed the Hungry, are now going to Access to Justice, as they should. Because access to justice is what is within the mandate of the courts. We're not here as a charitable organization. So the CPRE awards were spent to expand the program, and there's no question that the Law Society is invested in this. So when Derry came before the committee, they said, look, this is an important program, we've done a good job, but we need a breathing space to take this program to be self-sustainable. So it's like the programs that we run in other jurisdictions like London, Ottawa, and so forth, where they're self-sustaining and they don't come to the Law Society for additional support. And I said, that's a good program. It's not appropriate for a program like this to simply say, no, we're going to cut you off now. We will help you to become self-sustainable. We're going to give you some interim funding for 2 years to take you from a position now to a position 2 years from now where you're able to operate based upon a self-sustainable model like they operate in other jurisdictions. And to me, that makes sense. It's a prudent approach to the issues. I think that I accept what people say in terms of the Law Society becoming a charity and choosing between things. I don't think that we should. I'm not here to ask for funds for the Lawyers Read to Kids program. But I do think because of this program, its history, that we need to provide a window of opportunity within which it's going to transition to a self-sustaining program. And that may involve reducing the program to a level that is more sustainable than the current program, or it may not, because it may be that this help enables them to achieve funding sources and partners that makes the program at its current level self-sustaining. But I have confidence with the people we have there that they will take this as a window, and 2 years from now, we will no longer be funding this organization. Thank you, Treasurer.
Thank you, Mr. Brett. Next, Mr. Rosenthal.
Treasurer, I rise for the first time in Convocation to strongly support this initiative. As Derry said, I'm involved in a committee that runs a golf tournament called the Bugsy Newman Ken Danson Golf Tournament that to date has raised $550,000 for Lawyers Feed the Hungry. It is a very difficult task to raise the money, and it's getting harder and harder every year. Every single year, a great number of people on our committee say, we just can't do it anymore. And the reason why there's this core group on the committee that says we have to do is that we know that if we don't raise the $40,000 or $50,000 that we do every year, meals are not going to be served. And we know that there's going to be dramatic changes and cuts to the program if we don't raise that $40,000 or $50,000. The bottom line is the people on the committee, myself, we're amateurs. We're hacks. We sit and we cut and paste our emails and think of who we haven't reached out to before to beg them to sponsor a hole, knowing that if we don't, people aren't going to get served a hot meal in the city. Like Julie and I served a meal for the first time, embarrassingly, and it inspired me in telling the other committee members that we have to keep on going. And I know and I'm hopeful that if we got some professional help, we could raise a lot more money and at least be as sustainable as we are. So that's why I strongly support this initiative.
So Mr. Galati is next, followed by Ms. St. Louis.
I'll be briefer than I usually like to be, Treasurer. Thank you. I'm supporting this motion. However, I've never been comfortable with the Sally Ann approach to the Feed the Hungry program because of my personal experiences with hunger and poverty. I say, in accordance with what Mr. Murray just said, that this should be part of the general budget. I disagree with Mr. Bruck that that's not part of our mandate, and I would suggest that we should look at a yearly levy of $50 per lawyer in the province, with $50 to $60, which is 15 to 20 cents a day. If we're going to be serious about this and send a message that the lawyers are feeding the hungry, we should do it. That's not a lot of money for the profession to kick up at a maximum of 20 cents a day to give them their base $2 million funding a year.
Thank you, Mr. Galati. Ms. St. Louis.
I'm just going to focus on the elements and in part, maybe I'll start towards the end of Mr. Galati's comments. I'm a person that really does believe that we need to help those who are the most vulnerable. I don't believe that we need to help those who are the most vulnerable in every single place and context in which I work. And that's a challenge. So to me, one of the pieces, and I am rising in support of the motion, but I want to be very clear, it is not based on whether they do or don't manage to be sustainable in 2 years. I think it's a 2-year opportunity to become self-sustaining, but I'm not going to be open to entertaining in the 2 years they tried really hard. Can we extend it? Can we try for another couple of years? And I have a very basic reason for saying that. We're talking about people who are hungry undefined. Well, I can tell you, I've got law students who go to food banks. We've got students who are sitting in the articling process. They're people articling for free. They are hungry. They are all of those things, and we're not seeing them in this way. And I think those are the people to whom we owe our primary and immediate responsibility to. I'm extremely uncomfortable. I share everything that Ms. Vespri said about the direction of doing this with earnestness. Charitable models, handouts are not the way to deal with poverty anyway at the end of the day. This is a finger in the dike. We're not solving why they're hungry, we're just giving out a meal. So at the end of the day, I would just ask that we focus on ensuring that's a transition, but it's not a conditional transition. It's a 2-year opportunity. I believe that we should provide the highest level of quality that they can give them an opportunity to find fundraising. I'm engaged in it in other contexts. I agree with Ms. Murchie, it's extremely difficult. Money is very tight. They may desire, their desire is there, but I think the market model may be a problem no matter who has the task.
Ms. St. Louis, I have Mr. Cooper left in the room, and I just wanted to ask, is there anyone online who also wishes to be added to the list? Is that a yes or a no? Sorry. Hello?
Hello?
Is there anyone who wishes to be added to the list?
No.
It's a no. Okay, thank you. Sorry, Mr. Cooper, go ahead.
Thank you, Treasurer, and good afternoon. I rise, I don't have notes, because I didn't expect to speak on this, but I was part of, or I am part of the Audit and Finance Committee, so I think it's important that I can share some things with you that brought this before Convocation. First, the issue of whether this is in our mandate or not, in my humble submission to everybody here, is that could be a discussion 2 years from now. But I hope that we don't get there, because what's before us today is something that is absolutely within our mandate. Audit and Finance actually do go through the numbers line by line. I do, and I know Mr. Brett does wonderfully. And I can tell you from going through the numbers line by line, one of the things we know, and maybe Mr. Lapper can assist, is right now we have our staff that are spending an incredible amount of time, which costs us money, to the tune close to what is being asked for, and they're doing the job. And what is being proposed here is a temporary measure to help this program get on its own feet by having the ability to have a resource of a point person and potentially two, so they don't need to come back to us. So it's absolutely in our mandate to deal with the efficiency of the funds that we're using, because we are spending that money now, and we're trying to divert it in a proper way so it's transparent, so that in the future they will not be coming back to us. And if they do, they'll probably have my support anyways.
Thank you, Mr. Cooper. Okay. Either Mr. Warder or Mr. Miller, do you have any responses to the questions? Or
So just for the record, first of all, I wanted to indicate that the motion is brought by me, seconded by Ms. Lieber. And secondly, I just wanted to record for posterity that this important matter has led Mr. Rosenthal to wear a tie today, which we're very grateful for, and it is a beautiful tie. And I hope that because he's wearing that tie, everyone will support the motion.
Okay. In that case, I'm calling the vote. All those in favor? Okay. Any opposed?
The conference is no longer in lecture mode.
Any opposed on the phone?
Jan Richardson, and I'm opposed.
I'm sorry, did Mr. Byrd opposed? All right. Any others opposed?
Sorry, Treasurer, can you confirm that you got my opposition? It's Jan Richardson.
Yes, I did.
Thank you very much.
Oh.
I think he just hung up.
Oh, it was leaving the call. Okay. In any event, the motion's carried. So.
Thank you very much, Treasurer and members of Convocation. Thank you.
Okay. We have the report of the 3-year review of the Tribunal Committee. We also have a very short report from Ms. Corsetti. Not sure, Ms. Corsetti, would you prefer to give yours right now? Sorry.
Thank you, Treasurer. The Access to Justice Committee is pleased to report on the release of translated versions of the Law Society Handling Everyday Legal Problems Guide for First Nations, Métis, and Inuit peoples. As you know, the Law Society released its Handling Everyday Legal Problems Guide in English and in French in 2014. The guide was produced with the support of our partners, the Law Foundation of Ontario, Legal Aid Ontario, and Pro Bono Law Ontario. We initially printed 300,000 copies. 240,000 copies were distributed through media channels to those in Toronto area and to communities across Ontario. The remaining copies were distributed through our partners and to legal and community organizations. We also distribute a number of copies through the Law Society annual participation in Doors Open Toronto. The guide was very well received. As a result of its success, we have needed to publish a second printing. We continue to distribute it. The guide was then used as a starting point for developing tailored material for First Nation, Métis, and Inuit peoples, resulting in the publication of the Handling Everyday Legal Problem Guides for FNMI peoples. Our initial print was 2,000. We have distributed almost all of the English guides through our partners and are in the process of printing more. The guide has now been translated into Northwestern Ojibwe, Oji Cree, both syllabics and Roman, and Cree syllabics. This is the first time that the Law Society communication have been translated into FNMI languages, a major first for the Law Society. With the completion of these translated versions, we are working on a comprehensive distribution and communication plan to support them. We are also arranging to translate into the 4 Indigenous languages 2 fact sheets produced for FNMI people, hiring and working with a lawyer, our paralegal, and what the Law Society of Upper Canada does. I'm also pleased to inform Convocation that the Handling Everyday Legal Problems Guide for FNMI peoples will be translated into French and made available as soon as possible. The English and translated versions of the Handling Everyday Legal Problem Guide for FNMI peoples are available from the Law Society's information for FNMI people's website, together with our information at www.lsuc.on.ca Aboriginal Initiatives. I've brought hard copies of the guides in all currently available languages for benches to view and distribute as they see fit. The Law Society thanks its FNMI stakeholders for their invaluable assistance in designing the guide and for facilitating its distribution. In particular, we wish to again thank Grand Council Chief Patrick Madabi, staff of the Anishinaabe Nation, Union of Ontario's Indians, Mary Bird, Amanda Carling, and Liz Kajik. Thank you very much, Treasurer.
Okay, thank you, Ms. Corsetti. We have guests coming. However, I think we have time to do the Tribunal Committee report unless the chairs tell me they would like to put it over till the next meeting. But I think we can do that. We also have the Equity and Aboriginal Issues Human Rights Monitoring, which won't be that long, but which is important to do. So I'm going to call on the Tribunal review unless otherwise told. Mr. Wright.
There's good scope for lengthy discussion about the tribunal report. Maybe we should do the human rights monitoring, and that'll probably take us almost up to 12:30.
Well, we can go a little past 12:30. I understood you were going to be about 20 minutes altogether. Is that right, Mr. And Ms. Burchie?
Yeah. Yes, 20 to 25. I mean, Treasurer, if it turns out that there's a half an hour worth of questions, I guess
That's
we can't
problem.
say, but
Yeah.
certainly we shouldn't be that long.
Oh, Mr. Cooper.
I do have prepared questions that may take
You have a what?
some with respect to some of the issues.
Okay, while I'm thinking about it, I'm going to call on Mr. Shabas to do the next matter.
So thank you, Treasurer. It's a good day today at Convocation. We've reached out to support the profession with the mentoring task force. We've demonstrated our commitment to reaching out to the public with Feed the Hungry. And I want to tell you about a couple of other good things we've done in our profession since I've got the floor. And the first is just to mention one thing that has really been front and center in the news over the last couple of months in this country, which relates to the Syrian refugees. And I'm pleased to say that just before Christmas, the Law Foundation was approached by Lifeline Syria because they were inundated by volunteering from lawyers to help families and help refugees with the application process and all of the legal issues around settlement, and they didn't know what to do and how to coordinate and make sure services were provided properly. And we got a call quickly from Lifeline Syria, and the Law Foundation, within about 48 hours, approved a grant of $90,000 to provide assistance and coordination and support for the legal needs of the families and the refugees that are arriving. And it made me proud as a member of the profession that there was so much volunteering, and it was such a great opportunity for us at the Law Foundation to support that. And I wanted Convocation to be aware of that. The Treasurer mentioned the Day of the Endangered Lawyer event we had 2 nights ago. It was a wonderful event with speaking by Georgette Gagnon, who made us proud as a former employee, counsel in our discipline department, who has spoken about her incredibly brave activities in countries like Syria and Afghanistan, where she has been described as a voice for the voiceless and as the conscience of the war in Afghanistan. The stories she had to tell us and the difficulties and challenges in those areas in supporting human rights and speaking out against the powerful and the abuses there was quite remarkable. And it's available on a webcast on our platform for people to watch. The third piece of good news relates to Human Rights Monitoring Group a little bit, which is Myanmar. I read earlier this week that the first meeting of an independent lawyers association took place in Myanmar or Burma. It was even attended by the president of the International Bar Association. We've intervened many times in Burma, Myanmar. Mr. Copeland, one of the founders of the Human Rights Monitoring Group, has visited many times, and others of us have been involved, and so we were very pleased to see that movement forward as well. So with that, I want to turn to what's in the materials, and I just want to note, by way of information, that we have included a report that we presented at Convocation in October 2014, which is really a summary of all of the activities and interventions of the Human Rights Monitoring Group since its inception. We plan to update that in due course, but there are a lot of newer people in the room who were not here in October 2014, and I would really urge all of you to look at that report and get a sense of the work of the group and the scope of its interventions. We did it in the context of access to justice and our access to justice mandate, because we are speaking up in support of vulnerable lawyers who support vulnerable people who need access to justice. So with that, I'm not going to go through all of the proposed interventions with you. I would note that we are proposing interventions on behalf of 10 individuals from 6 different countries. A few highlights. One is for Puji Zhang from China. And we've been hearing a lot about the rounding up of lawyers in China lately. And Pu is an example of that. We wrote about him in September 2014 following his arrest, after he attended a session on the Tiananmen massacre. He was sentenced to 3 years in jail. We understand he's recently been released, but he's not permitted to practice. I met Puji Zhang in Hong Kong about 2.5 years ago, where he bravely came to a free expression conference. And one of the things he said to me when I talked to him about these interventions was that you should send your interventions to the families. And we've started doing that, and we'll be sure to make sure that Puji Zhang and others and their families, when the lawyer is in detention, as they often are, know about this and get support for that. A couple of other highlights. Sadly, we're sending India a letter. India, a strong democracy. Sadly, we've only written to India once before, but we have 2 lawyers who are being persecuted for representing the Adivasi people. We write to Syria on 2 matters. One relating to Razan Zatouni, who Georgette Gagnon singled out in her talk a couple of nights ago, not knowing that we were doing this again this week. We've written about her before, a prominent human rights lawyer, former winner of the Sakharov Prize, abducted 2 years ago and no trace of her since. We've also proposed interventions for lawyers in, again, Myanmar and Burma. We're not letting them off the hook. Vietnam, 3 lawyers, and a lawyer in Tajikistan. So the proposed letters and statements, Treasurer, are at tab 6.1.1 to 6.1.8.
There are 8 of them in total, moved by me and seconded by Ms. Donnelly.
Thank you. Any questions or comments from the room? Any questions or comments from the phone
Conference is no
line?
longer in lecture mode. What is it? I know.
Hello, you're online.
I don't have any.
They're not listening.
We'll take those as no questions. Okay, I'm going to call the vote. All in favor? Any opposed? Any opposed on the phone? Motion carried. All right, Ms. Murchie and Mr. Anand, we're keeping you to your time.
Thank you, Treasurer. On behalf of the Tribunals Committee, Mr. Anand and I are pleased to present the 3-year review report to Convocation this morning for information. I'm going to provide the framework and goals for the new tribunal model and the process for review. Mr. Anand will provide an overview of the input sought and received and our analysis of the implementation to date. You may recall that by way of background, in June of 2012, Convocation approved the new tribunal model with an independent chair. The report recommending this new tribunal model set out the goals that the model was designed to achieve. Now, the new model was built on process improvements underway before 2012, but it also represented a significant shift in direction. As a result, perhaps, the Tribunal Committee was required to undertake a progress review on the implementation of the model and report to Convocation in early 2016, and that's what we're doing today. Last year at this time, Convocation approved the review process, which required the appointment of a working group, Mr. Anand, myself, Ms. Corsetti, and Ms. Boyd. It also required the tribunal chair to prepare a background report providing factual information and data relevant to the 2012 goals. And Mr. Wright has done that. It's at tab 5.3 of your materials. And that report was very helpful to our review. So those 2012 goals can be found in your materials at tab 5.1, but let me summarize them very briefly. They relate to 4 areas. First of all, the goal was to advance tribunal reform with a focus on, number 1, transparency, number 2, fairness, number 3, cost effectiveness, number 4, separation of tribunals from the investigation and discipline stream, and number 5, a continuation of the role of benchers as an integral part of the adjudicative process. The second basket, if I can call it that, is related to, of goals, is related to excellence in adjudication and decision making, and that includes commitment to education and training in administrative law decisions. The third goal was to develop a system that fosters effective use of technology, and the fourth goal was to ensure efficient organization and administration. And our report considers implementation in light of those goals. Now, I just should say, by way of context, that the formal start of the Law Society Tribunal, the new one, was March 2014, and our review was conducted in the fall of 2015. So you can see that this report is necessarily a progress report, as the implementation that we're reviewing has really only been going on for 18 months. As a result of the short time frame, the working group was in a position to make some recommendations for ongoing steps and processes as the implementation continues, and Mr. Anand will address that. Let me say that in brief, the working group is satisfied that the tribunal's activities since implementation 18 months ago support the key components of the model and the goals that I've just set out, and that the committee is satisfied that the model is being thoughtfully and carefully implemented to reflect those goals. And with that, I'll ask Mr. Anand to provide the details.
Thank you very much, Ms. Murchie. I'm going to focus on what we did as a working group and as a committee and what we found. So firstly, in terms of the input we sought and received, and then our analysis measuring the criteria that Ms. Murchie spoke of that we set at Convocation as challenges in June of 2012. A separate independent identity, adjudicative excellence, enhanced tribunal processes, and cost effectiveness. We make the point in the report, in the Tribunal Committee report, that we were largely unable to assess these kinds of criteria from a numerical or statistical perspective. And one of the reasons is that, as Ms. Murchie said, we're 1.5 years into implementation, so it's difficult to draw numerical trends or patterns in comparison with the Ancien Regime. For example, in terms of number of appeals or appeals allowed, the numbers are too small to draw conclusions about a change, for example, in the quality of decision-making or reason writing. And secondly, and this is noted in a few places in the report, that the Law Society and the Tribunal did not design their statistical collection in 2012 or thereafter, or even over the last 18 months, for the purpose of, or to provide the information needed by this 3-year assessment. And so in a few places in the report, you'll see that it's suggested that statistics can be compiled differently, and with more time, they will acquire greater meaning, and more about that under the 4 topics that I'll address. So in terms of input, we had about 8 stakeholder sources of different types. The Chair's Practice Roundtable, which is the only one I'm going to refer to with any specificity. The Treasurer's Liaison Group. We canvassed all tribunal adjudicators. We canvassed all benchers. We, as you know, went before 4 committees of convocation apart from the Tribunal Committee to seek input. And we, through counsel who had represented licensees at least twice in the last 18 months, we sought their input as users, and we sought their clients' input through them without getting into difficult and sensitive issues, so that the lawyers could report. We didn't receive a lot of input there. Now, the details of, and there are some quite detailed summaries of the input that we received, are at tab 5.5, which is Board Books 177. The Chair's report, Mr. Wright's report in September 2015 is tab 3. The 2014 annual report of the Tribunal is tab 4. And these were all input, if you like, into our consideration. In addition to that, we had essentially unlimited access to the Chair and the Registrar and Senior Counsel, Mr. Wright and Ms. Nikowski, who provided a great deal of information as well as their views on several issues. In the report at paragraphs 29 and 30, you have a summary of the points that the Chair's Practice Roundtable, who consist of those who are the most regular counsel and representatives before the tribunal, what they had to say. The model is a significant improvement on the previous system. The location is a significant improvement. Appointed adjudicators have added to the quality of the tribunal process. They lauded the enhanced use of pre-hearing conferences to settle and or case manage applications, and they pointed and suggested the continuation of adjudicator education, particularly in evidentiary areas. In terms, and so I should say, just as we say in paragraph 39 of the report, that the overall, the input that the committee received did not propose changes to the model or to the approach being taken to implementation. We received, there was a good deal of engagement on some of the issues under the 4 headings, which I'll now take you through very quickly. In terms of tribunal independence, the independence of the tribunal is obviously in keeping with modern administrative justice principles and issues of transparency and perception, and they are embodied in the activities of the independent non-bencher chair and his job description, which is referred to at paragraph 51. In terms of this independence issue, I just want to mention two aspects that are covered in the report. One is the makeup of the tribunal and assignments to panels, and the other is operational independence. In terms of the makeup, we heard three different types of comments, in some cases contradictory to one another. There were too many non-bencher adjudicators appointed to the tribunal. That's one comment. A second is that the chair is assigning either an insufficient number of benchers to panels or an insufficient number of appointed adjudicators to panels. And thirdly, we heard from some that there is a plan to replace benchers altogether with appointed adjudicators. As we say in paragraph 60, we found no evidence to support any of these comments, and we set out some information about the composition of the tribunal in terms of its numbers. It's a large part-time tribunal, 92 members, 91 of whom are part-time, and it is broken down, as you'll see at Board Books page 74, amongst elected bencher lawyers and paralegals, ex officio and former treasurers, and those together, and bencher lieutenant governor and council lay appointments, and those together comprise 59 of the 91, I believe, members of the tribunal, and then you have convocation appointees who are set out as well. The numbers indicate that 56% of the tribunal consists of lawyer and paralegal benchers, 24 of paralegal and lawyer appointees. The manner in which appointments assignments are made to panels is directed by Regulation 107 of 07 and takes into account a large number of different factors: regional distribution, equity, diversity, practice areas, language requirements, availability for long or short hearings, conflicts, experience, and the nature of the case. And it's in part for all of those reasons that it's very difficult to form any generalizations about the individual assignments of panels. In terms of the size of the tribunal, that is, the large pool is a product of what Convocation decided in terms of benchers and non-bencher appointees, which is that there would be an asymmetrical process in which benchers would have a right to apply for the tribunal and to be placed as a member of the tribunal if they completed a significant introductory training that was put on in conjunction with SOAR, a 4-day training, whereas non-bencher adjudicators come through a different process and they're required to demonstrate adjudicative experience. With the large turnover of benchers in this election and the large proportion of the new benchers opting to apply for and be members of the tribunal, that is in part what contributes to the large pool that we have. So you have something like, you have 91 part-time members, you had something like 150 files per year, and you'll see from the chart at page 76 of Board Books that the there's approximately 1/3 less hearing time in the hearing division and in PMC and PHC, proceedings management and pre-hearings. There's approximately 1/3 less in 2015 than 2014. So there are fewer hearings to be assigned and fewer days to be assigned. All of these factors together have to be considered in terms of trying to discern anything in terms of the of whether one group rather than another is being used more than it should be. And we found no evidence to indicate that there was anything other than an appropriate consideration of this vast panoply of factors, which are indeed the factors that any chair or any chief justice has to, any chair or chief justice has the right to assign, and that's concomitant with the independence notion that I referred to earlier. And in this case, there is a statute and a regulation which is governing and which indeed provides for elected benchers on every panel in the normal course, subject to rare exceptions.
Mr. Nant, can I?
Timing.
Yes, I'm wondering if you could wrap up in, say, 10 minutes, because I want to make sure we have time for questions.
I will do that.
Thank you.
All right, so our conclusion in terms of makeup and appointments and composition is that the committee believes the system is functioning as Convocation contemplated in terms of a mix of non-bencher and bencher adjudicators. And indeed, you'll see at page 77 a chart which indicates the appointments of non-bencher adjudicators that are made by Convocation. And you'll see the first two rows are in fact appointments which the full-time chair did not play any significant role in. The first is between 2007 and 2012. The second is pursuant to the 2012 report, which itself provided for the numbers indicated there, 6, 4, and 4, of appointments of non-bencher adjudicators. And then post-2012, you have those on which the chair engaged in a detailed process of interviews and recommendations.
What pages are those on?
Page 77 of board books, I believe. All right, so in terms of operational activities, at paragraphs 64 and 65, we note that that operational activities which reflect independence are exemplified in the legislation, in the mission statement and core values that were arrived at in consultation with adjudicators within months of the arrival of the new chair, a distinct logo and letterhead, a distinct website, the evolution of the tribunal office manager position to a registrar role, Can Lee consolidation of reasons, the first dedicated Law Society Tribunal annual report, the chair's practice roundtable providing ongoing input from the most frequent users to the chair, and of course the tribunal being located now off-site. And so we heard a number of comments from those who are most involved in the new system, and I'll just highlight a few of them. One, that legal representatives have remarked that their clients are relieved not to attend at Osgood Hall. It's obviously an asymmetrical arrangement where they have to be escorted in and they have to go through security, and the Law Society Council would simply walk in from their offices. And in keeping with the nature of the proceeding, which is itself in itself difficult for the licensees. Duty Council commented on this in terms of the equal access as well. In terms of the second criterion of adjudicative excellence, the committee received positive input respecting a number of the components, in particular the more systematic approach being taken to adjudicator education, the establishment of a colleague review of draft reasons to enhance quality and consistency of approach. And in terms of going forward, we note at paragraph 72 some of the comments which should be considered by the tribunal committee and the tribunal chair going forward. There should be and these are important, that we heard comments that led us to record that there should be a universal commitment from all panelists to engage and be seen to engage with the lay panel member, and that is during hearings, apart from obviously beyond hearings. Secondly, that in terms of data collection, as we noted, there are difficulties with that at this stage, but the committee should be monitoring in conjunction with the tribunal chair and the registrar information relating to this difficult interaction of a very large part-time tribunal and the constant striving for adjudicative excellence, and also the issue which is flagged but has not been addressed in terms of the appeal division, and at what point, if at all, might it be said that it has outlived its usefulness in terms of establishing jurisprudence and in terms of error correction from the hearing division. We refer in terms of the operations of the tribunal at some length to pre-hearing conferences, which have roughly doubled in the last 3 years and which are important to resolving issues, to having frank discussions, to having multiple pre-hearings in which a pre-hearing adjudicator will follow up and will make him or herself available to the parties. Not just to discuss potential resolutions and agreed statements of facts, but also to case manage so that the important issues get the time that they're necessary, and vice versa.
Yellow light, Mr. Anand.
Sorry?
Yellow light.
Yellow light.
Flashing.
Okay. Almost there. At paragraph 76, there are a number of suggestions for the future in terms of collecting information. Exit surveys. We received these from the roundtable, that the biographies of the adjudicators that are going to decide the fate, in some cases, of licensees be put on, be available. That there be a greater effort, if possible, to secure duty counsel. So let me just say a word about cost effectiveness. You'll see at paragraph 78 that there are a whole host of factors which we record, which indicated to us how difficult it is, certainly in terms of dollars, to try to assess cost effectiveness. Indeed, in the 2012 report, we foreshadowed that by saying that the reforms and the streamlined processes and the fair, transparent processes that we would be seeking in convocation might not be readily measurable. Well, apart from anything else, there's a divided budget between benchers and non-benchers. One is within the chair's budget and the other is within audit and finance. On top of that, you have the 26 days. On top of that, you have benchers who do not accept compensation. On top of that, you have issues of how much time is actually being spent outside the hearing, because the only thing that is clearly measurable at this point is the time spent in hearings, the time that they began and the time they ended. Issues of Toronto versus out of town, obviously we can't be governed by the fact that it may be cheaper for someone to walk down the street in Toronto than to fly in from northwestern Ontario. That cannot be a criterion for guiding the nature of the internal tribunal processes. And then we set out some of the cost reductions that we anticipate. So overall, our conclusion and the Tribunal Committee's conclusion was that the 2012 report continues to provide a flexible and dynamic foundation for the continuing development of a modern regulatory tribunal. Implementation is going according to plan and appears to be going very well. And again, I want to acknowledge the important and excellent assistance of Sophia Spardakos and of course Chair David Wright and Registrar and Senior Counsel Grace Nikowski in assisting us in relation to this report.
Thank you very much. That was for information, so there's no motion, but I know there may be questions. I've been told there's at least one bencher who has questions. Anyone else? What? Mr. Wright. All right. Mr. Cooper.
I'll try to be quick. I did have an opportunity to speak to Mr. Anand beforehand, so he was aware of some of the issues or some of the things that I wanted to bring to Convocation's attention. I do have notes for this, so bear with me, please. So, I am sometimes called a new bencher. I thought that when I was elected, I was a bencher. And as a result, one of the things that I do believe that I bring to Convocation, and I've applied and I do sit on the tribunal, I believe that I bring some experience and wisdom from having my boots on the ground. I remember that Justice Corey said in Regina, or in Reeve Stevens in the Law Society of Upper Canada, and I can give someone the cite if they really do want it, but Justice Corey said, what constitutes professional misconduct by a lawyer can and should be determined by the discipline committee. Its function in determining what may, in a particular circumstance, constitute professional misconduct ought not to be unduly restricted. No one but a fellow member of the profession can be more keenly aware of the problems and frustrations that confront a practitioner. The discipline committee does today have on each panel a bencher. And I want, for the purpose of amplification, that a question to Mr. Anand, that this will be a continuing practice. I know that it is part of the mandate, and I understand that it's part of the regulations, but part of that regulation also allows, in certain unique circumstances, the chair can deviate from that. So that's where I'd like to start, if I may, sir.
The answer is certainly.
Thank you. Because it's important. One of the things that's important is because the creation of this new model allowed us to have a chair that would be independent and be able to run the operation, if I may say. So anything that I make in respect of comments regarding the chair is of the office itself and not with respect to the present chair, Mr. Wright, who I think has done a fabulous job. With respect to the issue of the chair, one of the things that I wanted to sort of bring to the attention of my fellow benchers is that in the chair's report, one of the things that and I may have misunderstood it, is that going forward, one of the things that is desired is the enhancement of statistics being taken. And I need to understand what these statistics are for and what they're meant to be. If the statistics are about monitoring the judgments and who's sitting on what panels, and their unique specifics, as opposed to aggregate statistics, I have great concerns because that takes it out of the issue of operation and more of policy, which should be before us at Convocation. So there is a broad statement and in the report that deals with the gathering of statistics and further review of dealing how to look at statistics. So I'm very concerned about that, and I think there should be discussion about it. I know we have limited time, so I'll stop there. The other thing that, as a bencher, I query with is that in a number of years, although they will come fast in the next term, when there's an election, there will be a whole slew of benchers that have not been part of Convocation before. Some will call them new benchers again. But at that point in time, I hope they do not have the same frustration that I met with, in that I agree there should be some education, there should be some training, you get your SOAR certificate, but it shouldn't be done several months after you're elected. That is not what the profession is looking for when they're creating us to assume our duties as fiduciaries here. It's got to be a little more complementary to those that are newly elected, and I hope to see that change. I also do not understand what the criteria is in the review of, for example, if I wish to be reappointed in 2 years to sit on the tribunal. I don't understand that review. It runs in contradiction with what Justice Corey said in Stevens. And I'd ask that we have a discussion about that to change that. Thank you.
Thanks, Mr. Cooper. Mr. Anand.
Well, just very briefly, in terms of the statistics, the types of statistics that we at the Tribunal Committee, I think, hope to have and to put forward to Convocation are the kinds that I discussed earlier, which relate to aggregate statistics. They're not going to relate to, I don't think I suggested that they would relate to the decisions of individual adjudicators. Apart from anything else, under our transparent process, you can put in search term Anand and you'll get all the decisions of Anand, and that will tell you whether there's any cause for concern or not. That certainly isn't going to be monitored by the Tribunal Committee. It's an independent tribunal, and it's not going to be monitored by Convocation, because Convocation doesn't monitor the adjudications in individual cases. With respect to I'm not sure what I can say about the timing of the SOAR related training. I think it's fair to say that it was scheduled at the earliest possible opportunity, and indeed it was difficult given all the variables in terms of getting people together and in terms of scheduling and cost and other things. Not sure if there's another question.
I'm sure you've heard the comments. It's quite possible, or quite open to the tribunal to take back some of these questions and comments and respond later. Yes, yeah.
2 years. Also, the evaluations. Yeah, I'm sorry, the evaluation process. That was a matter of some discussion. It was inserted in the 2012 report in keeping with the trends in administrative justice, where under Bill 212, for example, in the province of Ontario, appointments and reappointments are intended to be on the basis of merit, and merit is intended to be measured in some way, which is in keeping with adjudicative independence. And in fact, the process for evaluation in the 2012 report was specifically stated to be brought forward to Convocation for approval, and it was. And so that is the process that you can look back at the Convocation materials at that time that is being used at this point. I think it's fair to say, speaking for the chair, I guess to some extent, from what he has said, that is a process which he intends to evolve. He's only been at it for roughly a year and a half or 2 years at this point, but that it was clear that unlike judges, there will be an evaluation process for reappointment, and that was what Convocation decided virtually unanimously.
And if I may reply just very quickly, that's why I bring it up, because maybe they didn't have the forethought of where we would be today. It runs in contradiction with what Justice Corey said in Stevens. It runs in contradiction with the regulations requiring a bencher to be on the panel. I think that it should, and it's not something that is just part of a professional, or where only professional adjudicators are appointed. So I think it's different, and I'd like to have an ongoing discussion. It does not have to be here today, but it's something that I hope that others get engage in the conversation as well.
Happy to discuss that further.
Okay, thank you. Mr. Wright, anything new?
Thank you, Treasurer. The concerns are found in section 88 on page 122, where it says that every bencher, current, future, wishes to be a member of the hearing panel will be expected to apply. And as part of the application, the bencher will agree to a minimum amount of availability, agree to attend whatever training and education is required, and those unable to make such commitments will not be eligible for that round of appointments, but will be free to reapply when their schedule permits. I believe this works against the proper functioning of the tribunal. Benchers, by virtue of being elected, should automatically be on the tribunal. And it's not true that a new bencher is not qualified to sit as a third member of a panel featuring 2 experienced members. Availability is changeable. Sometimes a bencher cannot commit in advance due to health reasons in the family, but can fill in on short notice. When we get those notices by email, is anybody available on short notice? If you've been bounced off the panel, you can't volunteer on short notice to fill in. The rules allow a bencher to be bounced from the tribunal if they miss an adjudication session for reasons that may be beyond their control. It's unfair to non-Torontonians who have to come down here for a half-day session. We're not allowed to attend by teleconference, though we could. The optimum would be to be there in person, but sometimes you can't do it. It has nothing to do with the bencher's skills and experience and competence to sit on a panel just because they missed 1 or 2 education sessions. And to deny the ability of a highly experienced and skilled adjudicator to sit because of an attendance issue is nuts and counter, as I said, to the stated goal of involving benchers as much as possible in the process. Deleting such a bencher from the panel for no good reason increases the pressures on the remaining benchers. To maximize flexibility and availability, benchers should be automatically members of the tribunal. Thereafter, it is in the judgment of the vice chairs and partly the chair as to who is assigned to a given matter and who they'll sit with. If a bencher who's automatically on the panel...
Can I interrupt you, please?
I've got a minute. If a bencher doesn't want to do adjudication work, they can say so, but they should automatically be there. I think I agree with Mr. Cooper that there are aspects to this. I know there's no motion today, it's information. There are aspects to this that need to be rethought, and I'm hoping that the tribunal committee will do so sooner rather than later. Thank you.
Okay. Is there anyone on the phone who feels compelled to say something? Thank you.
Treasurer, can I just point out that Mr. Wright was referring to the 2012 hearings process report at page 122. It is there that Convocation made that decision.
Okay, thank you. That is going to complete our business. I have 2 very short matters to raise in camera, if staff could please.